The Senate will come to order. Will the clerk please call the roll?
Senators Baisley, Bridges, Senator Bridges,
Excused.
Buckner, Senator Buckner,
Excused.
Coleman,
Come on, man.
Cutter, Danielson, Exum, Fields, Senator Fields,
Excused.
Gardner, Janal, Gonzalez, Hanson, Hinrichsen, Hawkes Lewis, Kirkmeyer, Kolker, Liston, Lundin, Marchman, Michelson Janae, Malika, Senator Malika,
Absent.
Wait till you see his suit. You're going to change your opinion. When you see his suit, you're going to change your opinion.
Pelton B, Pelton R, Priola, Rich, Roberts, Rodriguez, Simpson, Smallwood, Sullivan, Van Winkle, Will, Winter, Senator Winter,
Excused.
Senzinger, Senator Bridges, Senator Buckner,
Present.
Senator Fields,
Mullica went that way. Mullica, no idea. Cool.
Senator Winter.
Yep.
Mr. President, Mr. President,
Here. The morning roll call is 32 present, 1 absent, 2 excused. We do have a quorum. Senator Bridges, would you please lead us in the Pledge of Allegiance?
It would be my pleasure, Mr. President. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Approval of the journal. Senator Priola.
Morning, Mr. President. Members, I move the Senate Journal of March 12th, the year of our Lord 2024, be moved or be approved as corrected by the Secretary.
You have heard the motion. All those in favor say aye. Aye. Opposed, no. The ayes have it, and the motion is adopted. Will the clerk please mark Mullica not as absent, as he was? For the record, Senator Mullica was absent for about 11 minutes this morning, and he is now present. Senate Services.
March 13, 2024, correctly printed Senate Joint Memorial 2 and Senate Joint Resolution 14, correctly engrossed Senate Bill 16, 26, 44, 70, 104, and 125, correctly re-engrossed Senate Bills 137 and 161, correctly revised House Bills 1060, 1086, 1139, 1159, 1155, correction, and 1347, correctly revised House Bill 1035, correctly enrolled Senate Bill 63 and 103.
Committee reports.
March 12, 2024, Committee on Local Government and Housing. After consideration on the merits, the committee recommends the following. House Bill 1007 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. The committee has had under consideration and had a hearing on the following appointments. Recommends that the appointments be placed on the consent calendar and confirmed members of the Colorado Housing and Finance Authority Board of Directors for terms expiring July 1, 2027. Albus Brooks of Denver, Colorado to serve as a representative of the public appointed. Santosh Ramdas of Denver, Colorado to serve as a representative of the public appointed. Jason Peasley of Steamboat Springs, Colorado to serve as a representative of the public appointed. The committee has had under consideration, has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed member of the Colorado Housing and Finance Authority Board of Directors for term expiring July 1, 2025. Steph Gafanchi of Lakewood, Colorado to represent the public, occasioned by the resignation of Nathan Peterson of Evergreen, Colorado, appointed. Committee on Finance. March 12, 2024, after consideration on the merits, the committee recommends following. House Bill 1056 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. House Bill 1044 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation. The committee has had under consideration, has had a hearing on the following appointments and recommends that the appointments be placed on the consent calendar and confirmed member of the Colorado Banking Board for term expired July 1, 2027. Cedar Cotwall of Highlands Ranch, Colorado to serve as a member of the public appointed. Committee on Business, Labor, and Technology has had under consideration and has had a hearing on the following appointments. Recommends that the appointments be placed on the consent calendar and confirmed member of the Pinnacle Assurance Board of Directors for a term expiring July 1, 2025. Angela Oakley of Centennial, Colorado to represent an employer whose liability is insured by Pinnacle, occasioned by the resignation of Mark Goodman of Denver, Colorado, appointed for a term expiring January 1, 2027. Mark Rolig of Vail, Colorado to serve as a member with experience in management and operation of insurance companies not competing with Pinnacle, occasioned by the resignation of Howard Carver of Silverthorne, Colorado, appointed for a term expiring January 1, 2028. Moa Haley of Denver, Colorado to serve as an employee of an employer whose liability is insured by Pinnacle, reappointed. The committee has had under consideration, has had a hearing on the following appointments and recommends that the appointments be confirmed member of the statewide Internet Portal Authority for a term expiring June 1, 2027. Samuel Tausig of Denver, Colorado to serve as a representative of the private sector appointed. After consideration on the merits, the committee recommends the following. Senate Bill 81 be amended as follows, and is so amended be referred to the Committee of the Whole with favorable recommendation.
Will the clerk please add Senator Winter to the roll? Third reading of bills. Consent calendar. Will the clerk please read the titles of all of the bills
House Bill 11,
on the consent calendar?
House Bill 1139 by Representatives Leader and Armagost, Senators Will and Exum, concerning the payment of death benefits after remarriage for surviving spouse of a state employee who worked in a job with a high-risk classification. House Bill 1060 by Representative Snyder and Senator Roberts, concerning implementing provisions of the Travel Insurance Model Act. House Bill 1086 by Representatives Holtorf and Amable and Senator Michaelson Janay, concerning the operation of the Denver Health and Hospital Authority. House Bill 1155 by Representative Velasco and Senator Cutter, concerning modifications to the statutes that guide the management of certain public safety emergencies. Senate Bill 70 by Senators Lundin and Zenzinger and Representative McLaughlin and Pugliese, concerning allowing online education programs to offer remote state assessment testing to students who attend online education programs and in connection therewith making an appropriation. Senate Bill 16 by Senators Zenzinger and Smallwood and Representative Snyder, concerning qualifications for state income tax credits for charitable contributions to nonprofit organizations and in connection therewith authorizing a taxpayer to make a charitable contribution for which the taxpayer may claim a state income tax credit to a charitable recipient organization through a qualified intermediary that forwards a contribution to the charitable recipient organization, allowing a tax credit certificate for the Colorado Homeless Contribution Tax Credit to include only the last 4 digits rather than all digits of a taxpayer's Social Security number and making an appropriation. Senate Bill 125 by Senators Pelton B. and Michaelson Janay and Representatives Evans and Basenecker, concerning the enactment of the Interstate Compact for the Placement of Children.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the passage of all the bills on third reading of bills, final passage consent calendar, which includes House Bill 1139, House Bill 1060, House Bill 1086, House Bill 1155, Senate Bill 70, Senate Bill 16, and Senate Bill 125.
Is there any discussion on any of the bills? Seeing none, the motion is the passage of all of the bills on the third reading of bills consent calendar. Are there any no votes? Senator Pelton.
Thank you, Mr. President. I wish to be recorded as a no vote on 1139, 1060, 1086.
Senator Pelton R. will be recorded as a no vote on House Bill 1139, House Bill 1060, and House Bill 1086. Senator Rich.
Thank you, Mr. President. I wish to be recorded a no vote on House Bill 1060.
Senator Rich will be recorded as a no vote on House Bill 1060. Senator Bridges.
Thank you, Mr. President. I wish to be recorded as a no vote on House Bill 1086.
Senator Bridges will be recorded as a no vote on a bill on the consent calendar, which is House Bill 1086. Senator Van Winkle.
Thank you, Mr. President. I wish to be recorded as a no vote on House Bill 1139, 1060, and 1086.
Senator Van Winkle will be recorded as a no vote on House Bills 1139, 1060, and 1086. Senator Smallwood.
Good morning, Mr. President. Thank you. I'd like to be recorded as a no vote on House Bills 1139 and 1060.
Senator Smallwood will be recorded as a no vote on House Bills 1139 and 1060. Senator Pelton.
Thank you, Mr. President. I'd like to be request a no vote to be on House Bill 1060.
Senator Pelton B. will be recorded as a no vote on House Bill 1060. Senator Baisley.
Thank you, Mr. President. I'd like to be recorded as a no vote on House Bill 1086 and on Senate Bill 044.
My apologies.
It's fine. I'll get it.
1086.
Senator Baisley will be recorded as a no vote on House Bill 1086. And now we all know how Senator Baisley will soon be voting on Senate Bill 44. Mr. Minority Leader.
Good morning, Mr. President. I request to be recorded on House Bills 1139 and 1060.
The Minority Leader will be recorded as no votes on House Bill 1139 and House Bill 1060. Senator Gardner.
Thank you, Mr. President. I wish to be recorded as a no vote on House Bill 1139 and 1060.
Senator Gardner will be recorded as a no vote on House Bill 1139 and 1060.
Yes, or no vote.
With a vote of 29 ayes, 5 noes, 0 absent, 1 excused. House Bill 1139 is passed. Co-sponsors, Senators Mullica, Danielson, Janal, Roberts, Coleman, Can, all right. Priola, Buckner, Michelson Janae, Jaquez Lewis, Sullivan, Marchman, Cutter, Gonzalez, with a vote of 27 ayes, 7 noes, 0 absent, 1 excused, House Bill 1060 is passed. Co-sponsors, Senators Henriksen, Priola, with a vote of 30 ayes, 4 noes, 0 absent, 1 excused, House Bill 1086 is passed. Co-sponsors, Senators Priola, Danielson, Buckner, Rodriguez, with a vote of 34 ayes, 0 noes, 0 absent, 1 excused, House Bill 1155 is passed. Co-sponsors, Senators Priola, Bridges, Michelson Janae, Exum, Roberts, Gonzalez, Jaquez Lewis, Buckner, with a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 70 is passed. Co-sponsors, Senators Buckner, Priola, Bridges, Michelson Janae, Exum, Cutter, Rich, with a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 16 is passed. Co-sponsors, Senators Priola, Winter, Marchman, Michelson Janae, Cutter, Exum, Zenzinger, Buckner, Henriksen, Janal, with a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 125 is passed. Co-sponsors, Senators Pelton R., Priola, Cutter, Buckner, Marchman, Jaquez Lewis, Danielson, Winter, Bridges, Janal, Colker, Will the clerk please add Senator Fields to the roll? Third reading of bills. Final passage. Will the clerk please read the title to Senate Bill 104?
Senate Bill 104 by Senator Danielson and Representative Hamrick, concerning the alignment of educational programs with registered apprenticeships and in connection therewith making an appropriation.
Senator Danielson.
Thank you, Mr. President. I move Senate Bill 104 on third reading and final passage.
Is there any discussion? Seeing none, the motion is the passage of Senate Bill 104 on third reading and final passage. Are there any no votes? Senators Van Winkle, Rich, Will, Gardner, Minority Leader Lundin, Smallwood, Kirkmeyer, Liston, Pelton B, Pelton R, Simpson. With a vote of 24 ayes, 11 noes, 0 absent, 0 excused, Senate Bill 104 is passed. Co-sponsors. Senators Exum, Sullivan, Jaquez Lewis, Bridges, Janal, Hanson, Mullica, Roberts, Colker, Winter, Majority Leader Rodriguez, Marchman, Fields, Priola, Buckner, Michelson Janae, Cutter, Henriksen, Coleman. Please add the president. Gonzalez. Will the clerk please read the title to Senate Bill 44?
Senate Bill 44 by Senators Colker and Hanson and Representatives Hamrick and Kipp, concerning the creation of a refundable income tax credit for qualifying public employees retirement association retirees and in connection therewith making an appropriation.
Senator Colker.
Thank you, Mr. President. I move Senate Bill 24044 on third reading, final passage.
Is there any discussion? Seeing none, the motion is the passage of Senate Bill 44. Are there any no votes? Senators Van Winkle, Baisley, Rich, Gardner, Minority Leader Lundin, Smallwood, Kirkmeyer, Liston, Pelton B, Pelton R, Simpson. With a vote of 24 ayes, 11 noes, 0 absent, 0 excused, Senate Bill 44 is passed. Co-sponsors. Senators Winter, Marchman, Bridges, Priola, Michelson Janae, Cutter, Henriksen, Jaquez Lewis, Sullivan. Please add the president.
They didn't notice me.
Will the clerk please read the title to Senate Bill 26?
Senate Bill 26 by Senators Roberts and Will and Representatives McLaughlin and Catlin, considering a requirement that members of certain state regulatory bodies who are appointed by the governor hold meetings to elicit public engagement and in connection therewith making an appropriation.
Members, just a reminder, we've been a little lax this morning, but we are on third reading. So let's keep the volume down a little bit. Senator Will.
Thank you, Mr. President. I move Senate Bill 026 on third reading and final passage.
Is there any discussion? Senator Gardner. All right, you can start talking again.
Thank you,
Just
Mr.
joking. Just joking. Senator Gardner.
Thank you, Mr. President. Well, when you reminded us that we're on third reading, I realized the gravity of the situation and thought that this bill merited some comments. I'm strongly in favor of this bill, but I wanted to tell you why, when I first looked at it, I had some question about, well, why do we even need to be telling these people that they need to have public meetings? But it turns out the events of the past few days have convinced me that members of the Wildlife Commission, they were previously required to hold 2 public meetings and so forth, and that we dropped that. But this bill renews the public engagement requirement for the members of the Parks and Wildlife Commission. I think, given the makeup of that commission, as it seems to be of late, a little public engagement to find out what their job was and who they represent might be in order. So I urge an aye vote.
Mr. Minority Leader.
It is rare that I find myself in separation with the Assistant Minority Leader, but I have a slightly different perspective on this particular bill, Mr. President. Given the events and the discussions of the last 24 hours, I don't think 2 times a year is enough. I think if you are fundamentally that disconnected from the brand of Colorado that's known across the state, across the nation, around the world, you probably ought to be hearing from the people of Colorado 12 times a year, not just twice a year. So I think twice a year is probably a good start, but given the circumstance, given the potential change of tone and perspective on what it means to be a user of the wildlife of Colorado, consumptive or non-consumptive in nature, I think you probably ought to sit down with the folks of Colorado 12 times a year, not just twice a year, and figure out what it is they are seeking, because these unelected but appointed boards have an enormous amount of authority. And hearing from the people of Colorado, if you can't hear from them through their elected representatives, probably ought to sit down and talk with them directly. So twice a year is not enough. 12 times a year would be better. Nonetheless, at least twice a year is a good starting point. Let's multiply it by 6 as we move forward. I urge your support of 026.
Seeing no further discussion, the motion is the passage of Senate Bill 26. Are there any no votes? With a vote of 35 ayes, 0 no, 0 absent, 0 excused, Senate Bill 26 is passed. Co-sponsors: Senators Marchman, Winter, Kolker, Janal, Cutter, Michelson Janae, Priola, Buckner, Sullivan. Is that it? Anybody else? No? Oh, wait. When did you guys get here? Minority Leader Lundin, Gardner, Rich, Baisley, Simpson, Liston, Kirkmeyer, Exum, Mullica, Smallwood, Henriksen, Coleman. You know what that's called? Veto proof. Will the clerk please read House Bill 1347?
House Bill 1347 by Representatives Durano McCluskey and Senators Rodriguez and Fenberg concerning the payment of the expenses of the Legislative Department.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the passage of House Bill 1347 on third reading and final passage. To ask for an aye vote.
Is there any discussion? Seeing none, the motion is the passage of House Bill 1347. Are there any no votes? Senators Van Winkle, Will, Baisley, Rich, Gardner, Minority Leader Lundin, Smallwood, Kirkmeyer, Liston, Pelton B, Pelton R, Simpson. I guess you guys missed that section of that bill that said if you vote no, you don't get paid next year. With a vote of 23 ayes, 12 noes, 0 absent, 0 excused, House Bill 1347 is passed. Co-sponsors. Mr. Majority Leader. Not doing it?
Barb wants to talk about one of the bills.
Just talk about it. Do you want to leave it all?
We can always come out. Barb wants to talk to the Senate bill first.
We can grant leave. They don't have to leave.
Okay. Right? Okay, we're going to grant you. All right, that makes sense. Thank you, Mr. President. Pursuant to Senate Bill Rule 21C, I move the Senate grant leave to the Joint Budget Committee to meet while the Senate is in session. Rule 21C.
The Senate will stand in a brief senatorial 5. Mr. Majority Leader.
Thank you, Mr. President. I withdraw my previous motion.
Members, just so folks know what's going on, the previous motion was so that the Joint Budget Committee can go to their committee meeting and finish, do some of the work to finish out the budget for next week. We are going to wait for that action so that members will be able to stay and participate in the Committee of the Whole for at least this first bill that will be taken up. And then, depending on time and whatnot, we will maybe come back into the Senate to grant them leave and then go back into the Cow. So, false alarm. General order, second reading of bills. Senator Coleman.
Thank you, Mr. President. I move the Senate resolve the subcommittee of the whole for consideration general order, second reading of bills.
You have heard the motion. All those in favor say aye.
Aye.
Opposed, no? The ayes having the motion is adopted. The Senate will resolve itself in the Committee of the Whole for the consideration of the general order, second reading of bills, and Senator Coleman will take the chair.
Committee will come to order and the Colt rule is relaxed. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move that the committee proceed out of order to take up Senate Bill 3.
The motion is to proceed out of order to hear Senate Bill 3. All those in favor say aye. Opposed, no. The ayes have it. We'll proceed out of order to hear Senate Bill 3. Will the clerk please read the title to Senate Bill 3?
Senate Bill 3 by Senator Sullivan and Representative Froelich concerning the authority of the Colorado Bureau of Investigation to investigate illegal activity involving firearms and in connection therewith making an appropriation.
Senator Sullivan.
Thank you, Mr. President. I move Senate Bill 003 and the appropriations and the Judiciary Committee hearings.
To the Judiciary Committee report, Senator Sullivan.
In Judiciary, we had one amendment that we moved through on, and it clarified work that CBI would be responsible with working with our local law enforcement and DAs to prosecute crimes.
Motion is the adoption of the Judiciary Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Judiciary Committee report is adopted. To the Appropriations Committee report,
And
Senator
in the
Sullivan.
Appropriations Committee, we appropriated money for the implementation of this, and I ask for an aye.
Seeing no further discussion, the motion is the adoption of the Appropriations Committee report. All those in favor say aye. Opposed, no. The ayes have it. The Appropriations Committee report is adopted. To the bill, Senator Sullivan.
Thank you, Mr. President, again. Thank you, members, for our conversation today. We're going to have about Senate Bill 3, which is the utilization of CBI and the background checks. I want to start for all of the people at home and the kids who are following along. What I want to get you to do is go to our website for the CDPHE. If you go there and you follow along, there is a block on the front about the Office of Gun Violence Prevention. If you click on the Office of Gun Violence Prevention, you can go down, and there's a list of options down there, and you can go to the Colorado Firearm Data Dashboard. And then on the data dashboard, there's going to be a lot of information, and one of the drop-offs is firearm sales data. So that's what we're going to be looking at today, folks, so you can all follow along. You don't have to take my word for it. The information is going to be right there in front of us. The numbers are going to be there. The denials are going to be there. Everything you need to know to help you follow along on this discussion we're having today is going to be right there in front of you. So check out CDPHE, check out the Office of Gun Violence Prevention, follow along on the dashboard with firearm sales and data. 10 years ago, now going on almost 11, they passed legislation that did mandatory background checks for all firearm sales here in the state of Colorado. And when that bill got passed, We patted ourselves on the back and told everybody what a great job we had done and how effective that was going to be moving forward to help us in this public health crisis of gun violence.
Senator Sullivan, 1 second. There's a lot of conversation going on. I want to make sure we're paying attention to the conversation that's happening in the world. Thank you very much. Senator Sullivan.
Thank you, Mr. President. What happened in the years after that, and you can see there on the data that we've supplied with you, the number of approvals that there have been since that time, since 2013, going to the present day, the number of approvals and the number of denials. What that graph fails to show is the investigations. We talk about, in 2013, 7,353 denials. Boy, that's great. That means that, we're really working on this to stop people, dangerous people, people that we have already identified in our communities that we don't want to have them own a firearm, that we've denied them the access to purchasing their own firearms. Really, what's happening is we haven't gone the next step on it. We haven't been able to do the investigations. That was a question that I had as the parent of a murdered child who was active down here at the state capitol while that legislation was getting passed, and in the subsequent years when they were trying to repeal that legislation, and we fought against it each and every year. What we were working on at that time was what was happening as we moved forward. I would ask a lot of questions as I would walk around the building here, but as just a private citizen, you don't always get the answers to your questions. I found out that once you get elected and you have questions to ask, you can go to Legislative Legal Services and ask that same question, and they'll give you answers. They give you answers as to what has been going on. And so I asked the question, okay, we've had all of these denials. What are we doing about these denials? Are we investigating any of these denials? And as you see in the chart there, it's got the reasons for the denials. And clearly, and nobody is debating this fact, well over half of these denials are because of clerical problems. Somebody misspelled their name. You can't read their writing. They filed it in the wrong area. They put the wrong birth date. Any of those kinds of things, those are quickly taken care of. But as we start moving down further, and we see that there's drugs being used, there's felony convictions, there's domestic violence involved in these denials. We wanted to find out what has been going on to investigate any of those and to further see if there was other crimes that were being committed in conjunction with these denials. During that first year, we had a total of 7,353 denials when we had 396,955 approvals. During that first year, we had one investigation. We looked into one of those 7,353 denials. The following year, we had 11 investigations. A total of 5 of them actually went to any kind of action where they would be presented to district attorneys. They would be having to answer some questions. During the first 5 years, and that's the information that I got from Legislative Legal Services, total of 36 during the first 5 years. So when I first got here, that's what I ended up doing, was working on some legislation to work on our background check denial system. I had legislation written up in 2019 when I first got here. Different leadership, different priorities, things were working a little bit differently, we didn't move forward with this. But I knew the problem was still out there. So this past year, I went and asked those same questions. What's been going on the last 5 years? And what's been going on is the same that had been going on the previous 5 years. We had, and you can see there through the chart, in 2020, we had a highest number of firearm transfers in Colorado history, nearly 500,000 firearm transfers, and we eclipsed that first year by twice as many. We had over 14,000 denials in 2020. I don't have any collective data for how many investigations or when we looked into those particular years. What I got is a group of those 5 years, and we did a total of 88 investigations during those previous 5 years. I believe in there, 36 of those were dismissed by district attorneys. 22 of them we actually took some type of action on. In all of this, this is for the other counties. This doesn't include the city and county of Denver. You have to go to the city and county of Denver yourself to find out that information. During those last 5 years, the city and county of Denver has investigated one. And if you look at the data, the CBI data, all of the other sales status, Denver and the city and county of Denver is one of the largest purchasers of firearms in the state. So again, folks, this is a problem, something that we should take a look at. And CBI reached out this year, and what we have decided and what we're hoping to be able to do is to create a team of individuals that will get that data and be able to, when they've worked with the local law enforcement about the problems that they're having, if they need help on the investigation of that, they can have the manpower to go and take a look and find out what the problem is. Because that's what we heard way back when I would ask the questions. It wasn't a priority for local law enforcement. They didn't have the resources. They didn't have the manpower to go and find out why so-and-so had been denied a firearm and they already had a felony conviction, or they were in the middle of adjudication on domestic violence or mental health concerns. So that was going to allow that kind of movement to go forward. Illegal gun crime continues to be a problem here in Colorado, and it's something that we talk about all the time. Just last year, we passed legislation about ghost guns, about the manufacturing of ghost guns. That's been going on for a year. We haven't really heard any of the data yet on how successful the implementation of that legislation has gone. Also, 10 years ago, we passed legislation about the high-capacity magazines, that there was none over the size of 15. We know that implementation really hasn't taken effect. During our committee hearing, we had individuals there who came in and had shown that they had gone in El Paso County to 12 different FFLs and still had the ability to purchase high-capacity magazines, 30, 50-round magazines in those stores 10 years after we had passed legislation that made those illegal. We heard this 20 minutes after we had the sheriff of El Paso County come in and tell us that he had the area of El Paso County completely covered. He was aware of every firearm infraction that went on in El Paso County, that none of them ever got by him, and that's what he was elected to do, and that's what he's been doing. Took less than 15 minutes for an individual to come up and show us the names and the locations of 12 different places in El Paso County where you can go in today and buy yourself a high-capacity magazine that is now illegal here in the state of Colorado. So that's another part of this is with the investigation team is to be able to check on and see if there are other things that are going on that they've been alerted to by citizens. There's going to be a tip line that's going to be able to allow people to call in and talk about the instance we had there in Colorado Springs, to talk about someone that might be selling and manufacturing ghost guns online. That's going to be a key part to this because this is an ongoing problem. This is something that we need people to be watching and working on all of the time because we see the public health crisis that is gun violence going on in our neighborhoods each and every day. I have an additional amendment that we can bring up later after we've had some conversation here. But what this amendment's going to do is we've been talking with sheriffs, chiefs, and the district attorneys about how we're going to implement this, how we can work together. And this is just a further clarification of how we can work with the district attorneys and local law enforcement. So interested to hear and have conversations about this process. And at the end of the day, I ask for your aye vote on Senate Bill 003.
Senator Gardner.
Thank you, Mr. President. Well, it's not clear after the sponsor's presentation whether he intends to offer an amendment or not, so I'm...
Very clear. I said I was going to offer one later on, but after we had a conversation.
Who are you talking to?
Just myself.
No more conversation. The conversation is for Senator Gardner to talk to the bill. Please proceed.
Thank you, Mr. President. Well, I am at a bit of disadvantage because the sponsor has an amendment to do something else to this bill. But I will talk to the bill as it is before us. You know, members, Colorado has a tradition, a constitutional tradition, of local law enforcement and local prosecution. And this bill started, I would have it read at length, but you can probably just read the 2 pages. You know, the bill is a shining example in its brevity of how it doesn't take much in words to have far-reaching impacts on how your state is governed, how the law enforcement in your state works, and with whom the power and discretion goes. So the bill starts out, and if you go to page 2, the back of the page, it really makes an amendment to Colorado Revised Statutes 2433.5-412, which is the functions of the Colorado Bureau of Investigation. And it adds something in the original bill. It says the Bureau, referring to the Colorado Bureau of Investigation, has the following authority, and it adds one. And the one it adds is to investigate illegal activity involving firearms statewide, including investigating illegal firearms transfers and attempts to illegally obtain firearms. Now, that seems pretty laudable. The sponsor started his presentation not talking about CBI, but about the Colorado Department of Public Health and Environment and the Public health issues involving firearms. Okay. But the bill is about who has the authority to investigate crimes in Colorado. And the original bill has language that says to investigate illegal activity involving firearms statewide, comma. Now, I wonder what kind of illegal activity involving involving firearms there might be. Well, we know that by that definition in the original bill, illegal activity involving firearms means drugs, motor vehicle theft, organized retail crime, various kinds of fraud, robberies, burglaries. I mean, basically, the bill as it was originally written gave the Colorado Bureau of Investigation the authority to become a statewide police force. The good news for your county commissioners is they could just get rid of the sheriff's office. Well, constitutionally they can't. Our local police departments could kind of go out of business because CBI would pretty much have it all because there aren't very many crimes that don't involve firearms. If you think there are, we'll just look at the list in the possession of weapons by prior offenders. You'll see that that list is extensive of crimes that involve firearms and that we think you shouldn't possess a firearm in the future. So the county sheriffs and the district attorneys came in to judiciary and said, this is a real problem here. Now, they're more circumspect and they have to all get along with each other. But what they really were saying, and what I heard was, and I've been around the building for a few months now, and so I start to pick up on what's between the lines. What they were really saying was, this is a huge power grab by the Colorado Department of Public Safety. And I have a lot of respect for that department, but I'm not sure that this was their idea. But I will tell you, it was a huge, huge shift, the way the bill was originally written. It's like, wow. And so the El Paso County Sheriff and the Teller County Sheriff and other county sheriffs said, this is a bad bill. We're against illegal firearms and all of its stuff. And by the way, Senator, we're supporting your possession of weapons by prior offenders bill that adds more crimes there. We need that help. We need that help. But we don't need the state to come and inject itself into our investigations without coordination. Now, the district attorneys said, you know, we prosecute the cases that are referred to us, provided they meet the basic standards of proof and the ethical standards for prosecution. That's their professional obligation. I read recently that one of our district attorneys said, you know, prosecutors are, and I'm paraphrasing a bit here, prosecutors are not about prosecuting, they're about justice. And so we don't prosecute things unless we believe we can prove the case, we can meet the standards applicable to prosecutors. In general, the American Bar Association standards for prosecutors. So here's our problem, I hear from some district attorneys. Yeah, there's a bunch of cases in CBI where they do background checks. and some of them probably involve crimes. Now, this is kind of interesting. The sponsor said there was something like half of all of these requests, background checks done, they're filled out. Half of those denials are clerical and administrative. No crime there. Somebody writes their name down and they write their name. Everybody calls them Bob. And they get used to being Bob when their first name is really Robert. And so they fill out and they're not thinking, they're in a hurry, or maybe, maybe they don't realize that they're not in the system, if you will, as Bob, they're in there as Robert. But they get denied. Was that a crime? Well, no, that wasn't a crime. And half of these things, according to the sponsor, are that. Well, I will tell you that's probably not very binary. My experience with the background check system as a legislator is this. We found in about 2009 or 10 or so, when I was in the House, that there were many people being denied because of situations like in 1970, whatever, in some state in a rural area, they got arrested for some felony, like stopping at a stoplight with the wrong state license plates, and they got run into the county jail, and that case just kind of sat there because the judge came around the next week and said, there's no crime here. But they had been arrested, and it had never been cleared. And these people were being denied firearms. So there's not just the misspelling and clerical cases, but there's all the people applying that say, well, I don't have a conviction. I got arrested 30 years ago when I was going too fast through wherever, and they arrested me and held me in jail, and my record never got cleared. We had to create a process for those people to force CBI to clear those cases one way or the other, sort of a put up or shut up. And by the way, it was very difficult. It is very difficult because criminal records and arrest records were not 30 years ago what they are today. So, those cases. And then there are people, it defies imagination, actually, if you have a verifiable felony that you would go and fill out the paperwork and hand it across the desk at your local federal firearms license dealer, who is audited regularly and checked regularly, an FFL, that you would submit that application. Because you're going to be denied. So I don't know, when you talk to those people later, why did you submit that? They say, well, I didn't think my felony was for whatever, a nonviolent thing, and they didn't think that they were prohibited. And by the way, the federal standards and the state standards are different. You know, Colorado has much to my chagrin and sometimes outrage, Colorado does not prohibit the possession of firearms by all prior felons in the way that the federal government does, and the federal government might want to make some revisions as well, but the state has different standards. And so you might have to be a pretty good jailhouse firearms lawyer to know whether you're going to get denied or not. And so the investigation of all of these, I think, often leads to that case is not prosecutable. But what the prosecutors say is, if that case were referred to us, if it were handed to us by CBI, we would review that case for prosecution. I mean, there was an implication in the testimony in judiciary that we needed CBI to get in this business because local law enforcement and prosecutors just weren't doing their job. And their answer was, well, one, we have to know somebody flunked a background check, and that's a CBI thing. And two, just because they were rejected didn't mean they'd committed a crime. And even if there was an arguable, colorable crime, you know, you could make out a prima facie case perhaps, maybe the proof wasn't there. You know, maybe it was as simple as a person who says, well, I didn't realize that my particular status prevented me from buying a firearm, or I didn't really know, and the only way to know was to submit my application. You say, well, you know, the form sort of says if you fill out this false application, you've committed a crime, but it's all stated in legalese that even a simple country lawyer has to read it 2 or 3 times. I mean, I've been consulted by people filing those and other kinds of similar government forms that say, I've not been investigated for this, or I've not been prosecuted for this, or I have no instances of this, and they come to my office and say, I don't want to commit a crime by signing this, but I have this set of circumstances. What do you think? Can I do this, or am I prohibited? I don't want to commit a crime. Well, the firearms background check form is pretty legalistic as it is. So we're not prosecuting these things. A little more complex than that. Now, what happened in judiciary? Well, I think the pushback from local law enforcement and district attorneys did have some effect because we passed an amendment. Now, first of all, we passed an amendment because, you know, no good bill apparently anymore can just be passed without virtue signaling by way of a legislative declaration. This legislative declaration, by the way, will not go in the statute, but we want everybody in Colorado to know that our hearts are pure and our intentions good. So it's not enough that we have the Colorado Bureau of Investigation and that the Colorado Bureau of Investigation is going to get authority to do certain things. We need to say that it's the intent of the Colorado General Assembly that the Colorado Bureau of Investigation investigate. I guess that's why they're called the Colorado Bureau of Investigation, because it's our intent that they investigate. Investigate what? Well, there's a colon there, so they're going to sweat. What are they supposed to investigate? Egregious attempts to purchase firearms by previously convicted felons who are identified through the instant check unit denial process. Well, I hope they thought that was their job to start with, without my declaration. Investigate unlawful activity involving illegal firearm components and accessories. Well, I guess that's what we're telling them later on in the bill, so I guess it wasn't enough to give them the authority which would have expressed our legislative intent. We need a legislative declaration to tell them what we meant. Wasn't enough to say what we meant. We need to tell them what we meant. And by the way, it won't go in the statute book, so it'll be buried back there in the session laws. Investigate tips and information relating to firearms violations as they are received, specifically focusing on straw purchases and personally manufactured firearms, commonly known as ghost guns. So we're going to have them investigate that. Paragraph 2 of the legislative declaration. The General Assembly finds that the Colorado Bureau of Investigation, okay, so now we're going to find something. We apparently have had a hearing and heard evidence. Maybe we've asked for people to come in who opposed our view, like at the courthouse. No. We just said it. We find that the CBI has operated in partnership with local law enforcement agencies on criminal investigations, and that the Bureau maintains a robust operating directive that outlines how investigators will, as soon as practicable after an investigation begins, communicate with local law enforcement agencies to determine the nature and extent of a firearm-related investigation. Well, if that's true, what we just said we found, I don't know why we even need the bill. Because we just found that they're doing what we are going to pass a bill to tell them to do, but they're already doing it. Now we need to tell them, in the last paragraph, we need to tell them what the General Assembly intends. Well, we intend what we say we intend when we pass statutes. I don't think, I mean, we do legislative declarations sometimes and put them in statute, or we do them if we think that there's going to be some, or at least this used to be what we did it for, if we thought there was going to be some misunderstanding of our intent. But if we intend something, we need to say it in statute. This really doesn't go in the statute, but the General Assembly intends that the CBI communicate with local law enforcement and the local district attorney in the jurisdiction where the Bureau is conducting an investigation into illegal activity involving firearms. Well, just because we intend for them to do it doesn't mean they will do it. And basically what I heard from local law enforcement is, you know, by and large, our relationship with CBI is quite good, but not always. Not always. And by and large, CBI has been doing what they should, but not always. I mean, after all, I don't think CBI has been a terribly big help to local law enforcement and prosecutors when it comes to DNA testing over the past several decades. 1,000 cases that CBI has placed in question. Already a bill for $7 million, but that's okay. The General Assembly intends that they do their job. We're going to pass that, and we're all going to feel better because we said that. Now, what does this amendment that got put on in judiciary do in substance? Well, it did sort of answer this concern of the original bill saying, investigate illegal activity involving firearms statewide, comma, including is not limited to that. So illegal activity involving firearms is most of it. So the amendment sort of closed that. And now the amendment, which replaced that paragraph, so we have a new subsection T, says, to investigate throughout the state. So, I mean, that goes to all four corners. Criminal activity involving firearms described in Article 12 of Title 18. I wasn't able to get Article 12, Title 18 off the shelf. Maybe when my colleague here goes, I'll take a break and go back and get it. And we can read all of Article 12 of Title 18 because it's relevant to this bill because firearms described. So we will describe the firearms, including investigating. I mean, you could have stopped there, but we go including investigating illegal firearm transfers and attempts, as described in Section 18.2, 101, to illegally obtain a firearm, period. When conducting an investigation, the Bureau shall reasonably communicate with local law enforcement agencies and collaborate with the local district attorney in the jurisdiction where the Bureau conducting an investigation in the beginning stages of the investigation. This subsection 1T does not authorize the Bureau to investigate other criminal activity encountered during a firearms-related investigation without consent from or in collaboration with the local law enforcement agency as required by law. Well, I'm kind of thinking that since we already said, I thank the senator from Monument, since we already said up here that in our legislative declaration, we said the General Assembly finds that the Colorado Bureau of Investigation is operated in partnership with local law enforcement. So why do we need to pass a law to tell them to do what we just found they always do? What else did this amendment do? This subsection 1T does not authorize the Bureau to investigate other criminal activity encountered during a firearms-related investigation without consent from or in collaboration with. I wonder which that is. Do you have to have consent or do you have to be in collaboration with? I collaborate with people that I don't consent to collaborate with all the time. I just have to do it. I don't know. That's kind of, that's kind of self-contradictory, I believe. The local law enforcement agency as required by law. I don't know what the amendment does. Sponsor hadn't offered it yet. Probably will require me to revise my whole reading of the bill because it's not very long, and any amendment probably is going to apply not to the declaration but to the operative part. And I'll have to come back here and engage in this discussion one more time. I may need a senatorial 5 or 55 to review it. What do I think this bill's about? I think this bill's about 10.1 FTE and $1.7 million to give CBI not only a broader charter, but to grow government in a way that local law enforcement agencies are already equipped to do and to be responsive to their city councils, their county commissioners, and district attorneys to their electorates to do their job. And, you can say these things aren't being investigated, and you can say, this is terrible, and the firearms crimes are terrible, but I have a very hard time getting a bill that makes possession of a firearm by someone convicted of car theft a crime that district attorneys would like to do. And yet we're going to spend a lot of time here. This discussion has not been that firearms crimes should somehow not be investigated or somehow isn't serious. It is. But the most rudimentary legislation to deal with that comes under the closest of scrutiny in this chamber and in committee, in this General Assembly. And yet the expansion of law enforcement powers to create the state police being now limited by the committee amendment to what I would refer to, and I'm going to start, just to put CBI on notice, I'm going to start referring to them as the state gun police. I mean, this is intended to be a change in their mission. And, you know, that may not be an illegitimate policy change, but let's call it what it is. It is taking the responsibility and authority from local law enforcement and placing it at the state police level. I asked for a no vote, and I eagerly await the offering of any amendments that might make this bill better.
Senator Henriksen.
Thank you, Mr. Chair. Colleagues, the debate on this bill really frustrates me, and some of the emails I've gotten on this bill really frustrate me, because for a long time, I've gotten emails and correspondence and phone calls and sat in diners and talked with constituents about firearm policies, and what I keep hearing over and over and over again is we don't need one more gun law. What we need to do is enforce the laws on the books. I don't entirely agree with that, but in a certain sense, I'm there. I have broken from my party several times on gun policy. I am proud to live in a city, and even in my city of 112,000 people, that sometimes has the feel of a city because it's over 100,000 people, surrounded by the most beautiful part of our state, I believe, and filled with the rural attitudes that come from that part of the state. And that applies to firearms. And we have a huge hunting culture in the city of Pueblo. And so I have a lot of constituents who are really, really concerned about increased regulation on firearms. And what I hear is, let's enforce the laws on the books. But I also hear from a owner of a firearms dealership in Pueblo County who's a friend of mine. It's where I've bought my firearms from, about how frustrated he gets at times because he sometimes feels like he's the only one that doesn't sell magazines over 20 rounds for miles around. That people get upset every time they come into his business trying to buy a high-capacity magazine, knowing that that high-capacity magazine is not legal in this state, and he won't sell it to him, but dadgummit, the guy down the street will, and he loses business constantly because of competition who's willing to flout the laws. We don't need one more gun law, let's just enforce the laws on the books. Well, that's a law on the book. I get emails all the time about a bill in the other chamber, the assault weapons ban. They say, we don't need this. We already have a high-capacity magazine limit. I actually agree with that position, but we're not enforcing the limit. So what I hear in this debate and in the correspondence I get in the phone calls is, let's not add more laws, let's enforce the laws on the books. Oh, But not those laws. Not the laws that we don't like. On November 1st, our city lost Olivia Francois. She was 14 years old, and she was murdered by her 15-year-old boyfriend, who had, for some time, had access and been apparently carrying around a semi-automatic pistol. Not at all legal for a 15-year-old to be in possession of a semi-automatic pistol. I would love if we had dedicated funds in the Colorado Bureau of Investigation to help before a child is murdered, to track down when firearms are falling into the hands of children, will be later used to murder other children, and figure out how that happened, because it cannot happen by any legal means. I don't have a lot to say about this bill beyond that because, frankly, it's a very simple bill. But I don't know of any other part of our laws and regulations where we say we don't need new laws, we need to enforce the laws we have, and then take every effort to block the enforcement of the laws that we have. Laws designed to save lives. Laws designed to protect the rights of law-abiding citizens of Colorado. So I ask for an aye vote on Senate Bill 3.
Senator Van Winkle.
Thank you, Mr. Chair. In the case that was just cited, of course, no one in Colorado, no upstanding citizen in Colorado would ever want an occasion like that to happen. And if it was known that a 15-year-old was walking around anywhere in the state of Colorado or any 50 of the 50 states, I would hope someone, of course, would call their local police department, their local sheriff, and that sheriff in that police department, whether it be a Pueblo sheriff, Pueblo Police Department in this case, or Douglas County Sheriff, or any, I would assume would respond very quickly and immediately, and in fact, dramatically more to the point than a statewide organization or a statewide task force, I suppose. That I'm not sure if it's headquartered here in Denver or where, but even if the CBI were able to get that phone call, I'm sure the very first thing they would do would probably be to call that local sheriff, to call that local police department and allow them to respond. Now, the firearms industry, members, we must not forget, is perhaps the most regulated industry in the United States of America. Just to open a gun shop, if someone were to do so, and I don't think there are many opening in the state of Colorado these days. In fact, it's quite the opposite. Just to open a gun shop, if one, if not multiple, federal firearm licenses are required. And with that comes mountains of paperwork, comes fees, renewals, and it comes with very periodic visits from the Alcohol, Tobacco, and Firearms, from ATF. Now, the ATF already can visit and does visit local firearm businesses, and they already can work with local law enforcement. So what is this bill intending to do? It is intending to create a task force, apparently with starting in its first year with 10 members of that task force, that upend essentially one of the foundational structures of our Colorado government, which is based somewhat on the doctrine of lesser magistrate in terms of that our local sheriffs are who we elect. They have authority over us. Our local elected officials can appoint a police chief that has authority over that region. And that sheriff and that police chief is different. It's built upon the idea of local control. But what this bill seems to do is it upends that paradigm that the state of Colorado has so well been founded on for so long, and upends the authority of that local police chief or the local sheriff. And I hope it's something that we can discuss today at length. I hope it's something that we can amend into the bill, because there does seem to be some acknowledgement in the bill draft itself that there does need to be cooperation with local law enforcement. However, when you're upending the structure and the foundational principles of local control and locally elected officials, especially when it comes to law enforcement in the state of Colorado, I think of things like immigration might be handled very differently in the city of Denver versus the city of Parker. Now, CBI, this task force of 10 people in the first year would be sent out to enforce laws that are currently, and I think this is also an important point, these laws that CBI and this task force will be sent out around Colorado to enforce, many of these laws are actually currently under court review right now and are likely to violate the Second Amendment in the Colorado Constitution. So many of the laws that CBI would be enforcing are currently tied up in courts because there is question about their legality and their constitutionality, especially following the Bruin decision. Because many of the laws that this task force will be charged with enforcing, or investigating, I should say, and then enforcing, do not fit the text, history, and tradition of the Second Amendment. Now, in the introductory remarks, both in committee and here today, the bill sponsor spoke very clearly about the idea of denials. So if someone, Joe Smith, goes and tries to buy a firearm and is denied, the main complaint we've heard and the reason for this bill is that denial isn't being investigated as often as it should be. Now, I will point out that local law enforcement does have authority to do that, and I will also point out that that's the system working the way it's supposed to work. If someone is not eligible to purchase a firearm in the state of Colorado, and that person tries to buy a firearm or receive a transfer of a firearm in the state of Colorado, even as a gift or a transfer, and it's they didn't pay money for it at a gun shop, but it's transferred to them. If that person's not eligible, such as a 15-year-old or someone, a felon, or someone that has, I don't know, a stalking charge pending against them, that person is run through the FBI background check, and they're also run through the Colorado Bureau of Investigation background check, just to make sure if there's one that's missed in one database or one that's missed in another, it is caught. And this person in Colorado that is not eligible for a firearm is denied. Now, that is altogether proper and just, but bringing a bill forward on the basis that that isn't later followed up with enough investigation, I think is a false pretense, and it brings it again to upend the structure of the authority of that local control, the authority of locally elected sheriffs and police chiefs in Colorado. And so I do have an amendment here.
Will the clerk please read the title to L005?
L005, amend the Judiciary Committee report.
Senator Van
February
Winkle.
5.
Thank you, Mr. Chair. And what this amendment does, this may actually look very familiar to those who are in the Judiciary Committee with us, because it's essentially the same one.
Senator Van Winkle, please move your amendment.
Thank you, Mr. Chair. I move L005.
To the amendment.
Thank you, Mr. Chair. And what this amendment does is it tries to accomplish three things in the bill. And it keeps the substance of the bill. It tries to put some guardrails, some belts and suspenders, if you will. I think probably guardrails is the best way to describe it. And it does it in three ways. First, in the first paragraph, it limits an investigation to an individual who has received a denial of a firearm transfer following a check in the National Instant Criminal Background Check System. And that, members, is what we've heard is the reason for the bill. So what the first paragraph of this amendment does is it says, okay, new task force, go ahead, you can investigate, and you can you can investigate any individual that applied for a firearm purchase and were denied. You can go look into why that might have been. You can see, what the reasoning behind it is. Is it simply clerical? Is it a paperwork issue? Is it if Bob was put on the application and not Robert, or Bill and not William? Go ahead, investigate that. But it limits it to that, which is, I think, what the bill sponsor is largely trying to get at. Paragraph 2, simply, the Bureau has probable cause to initiate an investigation. So they've looked into an individual that's received the denial of a firearm check, and then there is probable cause there for them to launch a more full, more substantial investigation into that individual to see if following charges or perhaps arrest or detain is necessary or required. And then at the very end, the third and final portion of this amendment speaks to that local control, to the authority of the local sheriff, and it says that the Bureau shall obtain approval from the sheriff and district attorney within the jurisdiction of the county in which the investigation will take place. So right now, the bill reads very loosely, and let me find that here. It says, the Bureau shall reasonably communicate. Now, reasonably communicate, that can be a lot of things. That can be a wide range of things. My idea of reasonable communication may be very different than a sheriff in Douglas County or Mesa County or El Paso County or Denver County. Reasonably communicate isn't a real standard, and so Part 3 of this amendment puts a reasonable standard in there, and it's obtain approval, as in CBI. So under this amendment, they see Joe Smith's been denied under either FBI or CBI background checks. They look into why and see, yes, there's a reason to investigate more, probable cause. And 3, telling sheriff from wherever, yes, sir, we are coming into your jurisdiction. We have probable cause and we have reason to investigate. We're coming into your jurisdiction to do so. So that is what the amendment L005 does. I ask for a yes vote to put some sensible guardrails around this legislation right now that has very few, if any, guardrails around it for this new task force. Thank you, Mr. Chair. I ask for a yes vote.
Senator Sullivan.
Thank you, Mr. Chair. Yes, we did see this exact same amendment in our committee, and we asked for a no vote then. We will ask for it again. And again, regardless of what it is I say, regardless of what it is you think you hear me say, we are destined to look at what the bill says. And the bill title designates that it is it is to investigate illegal activity involving firearms. That's what the basis of this one-page bill that has been amended is about. So again, I would ask for a no vote on L005.
Senator Gardner, to L005.
Yes, thank you. And I still am mystified that the sponsor may have an amendment that's not offered, but which could have been offered as a substitute or something, but, members, L005 is a floor version of an amendment that I think it was the senator from El Paso County, formerly known as Bob, who offered in committee. And what does it do? Well, it narrows up the operative, and really the only operative piece of this two-page bill. It narrows it up and says, if adopted, and I urge your adoption, it would then have the bill saying that the CBI is authorized to investigate, colon, and then a list of things, and you get down to T. It will then further limit, and in a way that keeps them from becoming the state police force, because that is not what we do in Colorado, to investigate cases involving illegal firearm purchases. Why do we sort of add the word purchases? Well, the bill started with illegal activity involving firearms, and as I said to you, and I was just reading the bill, I mean, some have come here and said, well, you know, about what I say or you say or whatever, read the bill. Well, the bill in its original language said, and investigate cases or crimes involving firearms. Well, that's just about everything when you come to violent crime. And I think CBI and the sponsors realized that wasn't going to fly in the chamber, so they narrowed it down. Not narrow enough. L005 says to investigate cases involving illegal firearm purchases, and then further limits that to say an investigation conducted by the Bureau pursuant to this subsection 1T, the one we're talking about, is limited to an investigation of an individual who has received a denial of a firearm transfer following a check of the National Instant Criminal Background Check System, InstaCheck, as described in 2433.5-424. You could look it up and I could read that to you. You know, if we dissected that, because it's cross-referenced here, that'd be another 15 or 20 minutes today, and the snow is coming, so I'm not going to do that. This section does not authorize the Bureau to investigate federal firearms licensees, as defined in Section 1812-101, which is generally the federal definition of FFLs, federal firearm licensees. Why is that? Well, as the senator from Highlands Ranch said, we already have the Bureau of Alcohol, Tobacco, and Firearms, the enforcers of federal firearms licensees. They're already subject to that. And as the senator from Pueblo said, his friend who has one of these licenses, and one of these is a retailer, as I understand it, says, these people are already coming and checking me. I'm being checked all the time. Senator from Pueblo makes the case. That's why this bill says they're not to, CBI's not to get in that business. They can call the ATF like everybody else. And in fact, they'll take their call quicker than they'll take mine. The Bureau shall not initiate an investigation pursuant to this section without probable cause. I mean, that ought to make sense. You can't just be going investigating willy-nilly. After all, if they could initiate investigations, they might start just randomly investigating you. Maybe they'd randomly investigate you because they don't like, they don't like you coming down to the well in the chamber and complaining about the expansion of their authority. They might start saying, well, you know, Senator Bob sure has been being a pain in our tush. Let's just investigate. Maybe he owns firearms. No, they need probable cause under this bill. And then it goes on to say what probable cause is, because we don't want them guessing or saying, oh, I had probable cause. The Bureau has probable cause to initiate an investigation of an individual pursuant to this subsection 1T only if there is a record that the individual was denied a firearm transfer following a check of the National InstaCheck system, or if the individual is prohibited from possessing a firearm. I think there's a missing word here, evidence of a violent crime or evidence of a violent crime involving the individual. I think the concept they're trying to get there is prohibited due to a violent crime, PALPO. And probable cause does not include verbal tips or social media posts. Well, we have to do that these days because people can put anything and everything out there on social media. Somebody called me a liberal on social media the other day. So we know that social media tips are not reliable. My point is, the sponsor began this support of this bill talking about the 14,000, I think was the number, denials in a year, half of which were because of administrative errors, and then you start getting down to whatever. This is trying to describe the denials that are because somebody's trying to get one when they're not permitted. And then to deal with the concern of we don't want the state gun police. We don't want the Colorado Bureau of Investigation to become the Colorado ATF, although the Department of Revenue operates as Colorado AT, I guess. Says, prior to beginning an investigation pursuant to this subsection, the Bureau shall obtain approval from the sheriff and district attorney with jurisdiction in the county in which the investigation will take place. You may go, oh, hold on there. You know, they got to get consent and approval. That seems to be a step too far. But recall the legislative declaration says they work well together. We, the General Assembly, find that they do. And we wouldn't be wrong. And since we find that they do, it's not too much to ask that CBI get approval and consent from the sheriff and district attorneys to do that. Because in our legislative declaration, we found that they all work really well together. I urge an aye vote on L005.
To L005, Senator Henriksen.
Thank you, Mr. Chair, and I'll be very, very brief just because I want to rebut something that was said, probably a misunderstanding about something that I had set up here earlier. My friend who operates a retail operation in Pueblo County, his frustration is that he is losing business because he is doing business ethically, honorably, legally. He will not sell a magazine that exceeds the 15 capacity limit. But he deals every day with people who find other retailers who will. And this bill would help get at that. And it would protect him and other dealers who are conducting their business in an honorable, ethical, and legal manner. It's my understanding that the NSSF came and testified in support of this bill in committee for that very reason. And so I wanted to make it clear that that was the point that I was making earlier.
Senator Gardner.
Thank you, Mr. Chair. Well, I appreciate that clarification from the senator from Pueblo. I truly do, because it helps me understand that his friend is upset that he's losing business because he's doing it legally and ethically, and there are people out there who break the law, and they ought to be stopped, and I agree about that, and he probably ought to report them. I assume, based on what the senator from Pueblo has said, the Pueblo County Sheriff would be all over that. You know, I hear from cannabis purveyors all the time that they're losing business to the street corner. But all I know to do about that is report it and expect law enforcement to do what they do. And I would assume that the Pueblo Police Department and the county sheriff in Pueblo, if that was reported to them, would exercise all due diligence to enforce the laws of the state of Colorado, and that the district attorney, a gentleman I have known for many, many years, we served in the Air Force together as judge advocates, would be all over that if there was a case to be made. So I appreciate the clarification from the senator from Pueblo. I urge and I vote on L005.
Senator Rich.
Thank you, Mr. Chair. And I rise in support of Amendment L005. Now, I wasn't in judiciary when this bill came forward, but my sheriff was. He actually even testified. And he does know that we are talking about this bill right now, because I've been getting texts from him. And this was one of those sticking points for him, is just asking the CBI to get approval. And that doesn't seem like a really big thing. And so I really appreciate the senator from Highlands Ranch bringing this amendment. And I am urging an aye vote on this.
Senator Will, 2L005.
Thanks, sir. So I stand in strong support of L005, and the main reason for that is, in any investigation, and any criminal investigation, you have to have probable cause. And it says right here, under the 1T, which I noticed happened in the committee, I think it was the Senate Committee, Judiciary, that the committee report, because originally when we were talking about investigating any firearm, illegal firearm use, I thought, well, heck, that's going to make CBI all the game wardens in the state too. If I shot an illegal elk or a deer with a firearm, and all of a sudden that's an unlawful use of a firearm, but would CBI be the investigating body and agency for that? No. But the Bureau, under L005, the Bureau has probable cause to initiate an investigation. That's just basic law enforcement. To initiate an investigation or to be charged, you have to have probable cause. And this is talking about only if there's a record that the individual was denied a firearm transfer following a check of the National Instant Criminal Background Check System. If the individual is prohibited from possessing a firearm and the evidence of a violation of crime involving the individual. Of course, probable cause does not include verbal tips or social media posts. That just common law enforcement, and I strongly support this amendment. Makes a lot of sense.
Seeing no further discussion on L005, the motion is the adoption of L005. All those in favor say aye. Aye. Opposed, no. The noes have it. L005 is lost. To the bill, Senator Kirkmeyer.
Thank you, Mr. Chair. Members, I rise in opposition to Senate Bill 3. I'm sure that's of no surprise. Hopefully, and it was somewhat discussed here already, but hopefully you all read the legislative intent that was added in, amended into the bill, and there was another amendment to the bill as well. First of all, I just want to say this. I mean, we heard discussion about transferring and doing illegal activity. Gosh, call the sheriff. If you know of that there's illegal activity occurring or an illegal transfer, call the police chief. Just call them. Basically, this bill just pretty much trips all over the jurisdictional issue of both the sheriffs and other local law enforcement folks. The amendment that was included says, shall reasonably communicate with local law enforcement agencies. I'm not really exactly sure what that means. That is normally not how it happens between law enforcement agencies, that I guess they give them a call. I don't know what that means. But they'll reasonably communicate with local law enforcement agencies and collaborate with the local district attorney. Well, I'm glad we put it in here that they have to collaborate because they're supposed to. They have to collaborate with the district attorney. But again, this is really a jurisdictional issue. This is an overreach by a state agency. And it's not even consistent with existing law. So that's one point. The other point is this. In the new legislative intent, it talks about item C, tips and information, that the Bureau of Investigation investigate tips and information relating to firearm violations as they are received, specifically focusing on straw purchases and personally manufactured firearms, commonly known as ghost guns. Apparently, during some discussion, and I agree with the good senator sponsoring this bill, that what is said doesn't matter as much as what is actually put into writing. But I'm just going to point out that if the discussion is that they were supposed to have a tip line, those cost money. I don't know if that's supposed to occur, but that was part of the discussion that occurred with the liaison to the Department of Public Safety, who spoke to a tip line. And I would just like to point out that there is no discussion with regard to that in the fiscal note. And while I'm talking about the fiscal note, the reason I voted no on this so strongly in appropriations, Senate Bill 24003, is because the fiscal note on this is $1.5 million. And members, we have had a process in place that prior to the long bill being introduced, we don't try to push through these big ticket items, these large appropriations. And we had this discussion in appropriations, and I think it bears with repeating to some degree here, and it is related to this large fiscal note that went through appropriations prior to the long bill. Hopefully everybody realized that prior to trying to hear this bill, we were trying to get permission, the Joint Budget Committee members were trying to get permission to leave so that we could go finish up the long bill, which we have to have done by Friday. We're supposed to have the draft long bill by Friday. Yet instead, here we are, and part of the reason is because this bill got to go through appropriations. Normally, before the long bill is introduced, if there are bills that have appropriations of $1.5 million on them, and in fact, before it got to appropriations, it was $1.7 million, and 10 to 11 FTE. This is actually 11 FTE. When it says 10.1 in total FTE, that's because they're not accounting for a full year. You need to look at the next year where it says 11. 11 FTE and $1.7 million. We pushed it through appropriations. When normally we only see bills that are maybe 20,000, 30,000, 50,000, maybe even 100,000. We see bills that don't require general fund appropriations. that get put into appropriations prior to the long bill being introduced. So we all need to understand that if we're pushing through these bills because, I don't know, there was some special polling or something taking place in a certain caucus, that's wrong. And we wouldn't have had to ask for permission to leave today had we not had this bill and had it not get pushed through appropriations. So one, I'm not too happy about the process and how we just basically didn't follow process. But two, this bill again steps all over the jurisdictional issue of local law enforcement. It is up to the police in your municipality to investigate these crimes. It is up to the sheriff in the unincorporated portions of the county to investigate illegal activity. It is not up to the Colorado Bureau of Investigation to do this simply by just reasonably communicating with local law enforcement. This is not, and typically not, part of their jurisdiction. And I'm just going to read from you from law why I say this. Under 24-33.5412, functions of the Bureau. Functions of the Bureau. When assistance is requested by any sheriff, chief of police, district attorney, head of a state agency, or chief law enforcement officer, and with the approval of the director, that would be the director of the Criminal Bureau of Investigation. After they get approval from the director to assist, not just go out on their own, not to go jump into somebody else's jurisdiction when they don't really know what's going on in that jurisdiction. What if the sheriff, what if the local law enforcement has a whole process in place where they are where they're going to do a sting, where they are aware of the illegal activity, and they're putting together their own investigation? And in marches CBI to the rescue, I guess, or maybe just to screw it up. That's why there are things in the statute that say when assistance is requested by the sheriff, the chief of police, the district attorney, the head of a state agency, or the chief law enforcement officer. That is why also they can't just go fumbling their way in unless they have approval of the director, unless they're actually coordinating, working together, and not stepping on someone else's jurisdiction, but honoring that jurisdiction and actually partnering with them. And it gets better. They don't get to just go march into or go investigate in the possible crime related to arson. Here's what the statute says. The Bureau has the following authority when requested by the chief of a fire department or his or her designee and approved by the director. The Bureau may assist in the investigation of a possible crime related to arson. And let me just go on further. When such request is made by a fire department, the fire department shall notify the appropriate law enforcement agency that a request for assistance from the Bureau has been made. Are we understanding? I mean, if this is what reasonable communication is, then we should have put that specifically into the bill. Otherwise, I am thinking that reasonable communication does not mean that you have to get a request from a law enforcement agency or from a fire department, that you have to go talk to your director so he knows what you're all doing. That's reasonable communication, what we got in law right now. So I'm not sure why we just didn't repeat it in this new law that we're trying to pass. Let me just go on further. This is still in 24, 33.5, 412. This is all the way down in 8A. And now in the title here for this little section, it talks about functions of the Bureau, interagency cooperation with reporting functions, processing time for criminal history record checks, computer crime, synthetic cannabinoids enforcement. So computer crimes. Here's what they have to do if they have a cybersecurity problem. Again, they do not get to just enter into someone else's, either the sheriff's or local law enforcement, police chiefs, or the district attorney's jurisdiction. 8A, the Bureau has the authority to conduct criminal investigations relating to cybercrime violations pursuant to a certain section. When violations, here we go, here's the catch point. Here's where that reasonable communication comes in. When violations are reported or investigations requested by law enforcement officials or the governor. So again, when violations are reported or investigations requested by law enforcement officials. That's what we have in the law. So I'm not an attorney, but if someone asked me what I thought reasonable communication meant, I would say, well, I'd go back and refer to the law. And apparently it means that the law enforcement agency needs to request it. In other words, they need to consent to it. In other words, they need to know when some other law enforcement agency called the Criminal Bureau of Investigation is in their jurisdiction. And when they are investigating a crime, so that we have an understanding that they're not tripping all over someone else's jurisdiction and not messing up that local law enforcement agency's investigation. Reasonably communicate? How about we know exactly what's going on before we jump into somebody else's jurisdiction, and before we do that without their consent or their request?
There is an amendment at the desk. Will the clerk please read L008?
L008,
Senator
amend the
Kirkmeyer.
judiciary.
Thank you, Mr. Chair. I move L008.
To the amendment.
Thank you, Mr. Chair. So, it's pretty easy, folks, if you were listening, because I just read what is in law and what I believe to be that interpretation of reasonable communication. So here is currently what is in this bill in the amendment. That the Criminal Bureau investigation has, let me just read the whole thing here so I don't mess it up. I already moved it, yes. So the Bureau has the following authority. And in the original bill, it said to investigate illegal activity involving firearms statewide, including investigation illegal firearm transfers and attempts to illegally obtain firearms. Here's what the amendment read. To investigate throughout the state criminal activity involving firearms described in Article 12 of Title 18, including, wow, and so this one just really opened it up. It opened up everything in Title 18, Article 12, including investigating illegal firearm transfers and attempts as described in Section 18-2-101 to illegally obtain a firearm. When conducting an investigation, the Bureau shall reasonably communicate with local law enforcement agencies and collaborate with the local district attorney in the jurisdiction where the Bureau is conducting an investigation in the beginning stages of the investigation. And then it says that right now in law, in this bill, this section, subsection 1 small t, does not authorize the Bureau to investigate other criminal activity encountered during a firearms-related investigation without consent from or in collaboration with the local law enforcement agency as required by law. Well, that's pretty good language, that last sentence. Because again, can you imagine the CBI goes in and starts off on an investigation, and they reasonably communicate it? I mean, I suppose some people might think reasonable communication is, well, we called them and left a message. Well, we didn't check with our director before we did this, but we called my buddy that I used to work with in the city of Greeley and said, hey, we're going to start this investigation because we got a tip. I don't know where they get the tip from unless they're going to start a tip line, which, by the way, they don't have a fiscal note for. Once again, we shouldn't even be hearing this bill yet because Long Bill hasn't been even drafted yet. But once again, can you imagine CBI decides reasonable communication? Well, I sent an email. Maybe they sent him a text message. I mean, do they have to give him 24 hours notice? I mean, is that reasonable? Gosh, we just got this tip and we want to run out the door and go investigate it. Reasonable communication? What the heck does that mean? I'll tell you what I think it means and what my sheriff thinks it means. It means that the CBI could probably come into his jurisdiction and interfere with an investigation that they are doing regarding illegal activity. And on top of that, that legal activity that they're investigating may lead to other crimes. There may be other things involved in that that aren't related to firearms. That now, the investigation that the CBI is doing, they're not going to do anything about those other crimes. I mean, we've just missed the boat all the way around. Because somewhere along the line, I guess we think our sheriffs, their deputies, and our local law enforcement folks, you know, our police chiefs, all those people that you pay for those of you who live in a city, all your municipal local law enforcement folks that are district attorneys, man, they just aren't doing their job. They must just not be doing their job. Here's what the amendment says. So it says that instead of saying when conducting an investigation, so they're already in the act of doing an investigation, instead of saying when conducting an investigation, the Bureau shall reasonably communicate with local law enforcement. I mean, my God, why do we even have to say that? Are we trying to say that law enforcement shouldn't communicate to each other, that we have to like mandate it now in law, that we have to put it in law that they shall reasonably communicate? We really seriously have to tell them that? Man, I would question the people we're hiring if we have to tell them shall communicate. But anyways, when conducting an investigation, the Bureau shall reasonably communicate with local law enforcement. And that would be stricken. That language would be stricken. And the language that would be inserted is, prior to beginning an investigation, the Bureau shall request and obtain consent from local law enforcement agencies. By the way, local law enforcement agencies include the district attorney's office. Typically in some of these investigations, you know, the sheriff, the police department, they usually like to involve the district attorney, make sure, you know, they've got to get warrants, things of that nature. Just want to say. So again, this would say, when conducting an investigation, the Bureau shall, instead of saying when conducting an investigation, the Bureau shall reasonably communicate, it would say, prior to beginning an investigation. Prior to running yourselves off after you just got this tip that you don't really know where it came from, you don't really know how good it is, but you guys got this tip, prior to you running off, getting into someone else's investigation possibly, or interfering with their jurisdiction, prior to beginning an investigation, the Bureau shall request and obtain consent from local law enforcement agencies and collaborate with the local district attorney. Again, I don't know why you need local, but whatever. But collaborate with the local district attorney in the jurisdiction. Folks, this is consistent with law, and this is good. This is consistent with good practice, and this is reasonable communication. Before one law enforcement agency decides to jump into someone else's, go running into someone else's jurisdiction, there should be consent and there should be request. Period. That's what partnership is. That is what reasonable communication is. And you don't have to take my word for it, because it is all over the statute with regard to the CBI, with regard to the Bureau of Investigation. A1, A Roman numeral 1, when assistance is requested by a sheriff, chief of police, district attorney, head of a state agency, or chief law enforcement officer, and after approval with the director, then the CBI gets to jump into somebody else's jurisdiction. When a fire chief, and after approval by the director, when they make a request, then the Bureau may assist in the investigation. They don't go take it all on. That's not their job. And even in cybersecurity acts, it's very clear. They don't get to just go run into this. They do all the forensic. You know, they have cyber forensics. Thank you. That's what they're supposed to be doing. But when investigations requested by law enforcement officials or the governor, again, they don't get to just go running into a situation that they don't know the whole situational awareness of. There is a command structure that takes place. There is a need, an absolute need, that everyone involved in an investigation has the situational awareness and knows what's going on in that situation, so they don't put at jeopardy, one, the investigation, or two, the law enforcement officials' lives, their safety. There's a reason why it needs to be requested. There's a reason why consent needs to be done. And it doesn't happen if it's just reasonable communication. That is what's wrong with this. There is no one saying here today that we shouldn't have these investigations. I am not saying that law enforcement should not go investigate illegal transfers. They should, and they do. What I am saying is we don't need to mess it up by saying that the Bureau of Investigation, Criminal Bureau of Investigation, can just go into someone else's jurisdiction with not having a situational awareness, with not being requested, with not even getting their consent. Phone call, an email, a text, doesn't do it. So again, I'm asking for your approval, your aye vote on L008. Let's be consistent with law. Let's make sure that we protect the investigators, that we protect our local law enforcement and our CBI guys, that everyone is aware of the situation, that they are partnering together, that they are working together. So, prior to beginning an investigation, the Bureau shall request and obtain consent from the local law enforcement agencies and collaborate with the district attorney so that we don't have to hear something go wrong and someone lost their lives because people only reasonably communicated. I ask for an aye vote on the amendment.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote on L008. We have been in contact and conversation with the district attorneys, with the sheriffs, with the chiefs since the inception and the beginning thought process on this. And I guess I will apologize for not bringing the bill or the amendment that I have that will address some of these concerns, but I just saw a line forming up over here, and I was hoping to keep the line moving, so that's why I went right to them. But I didn't know, of course, because we haven't had the communication on this type of stuff about what the concerns were, and we are addressing the concerns from our district attorney, from our local sheriffs, from law enforcement. So I would ask for a no vote on L008.
Senator Kirkmeyer.
Thank you, Mr. Chair. Well, if the amendments are so similar, then I'm having difficulty understanding why there's a no vote. If the good senator from Centennial wishes to share his amendment, I'm happy to pull my amendment if they read the exact same so he can get the amendment passed. But I'm having a hard time understanding why we're voting no on amendment if it's the exact same as his. So if that's the case, then I ask for an aye vote. And I believe that I was very respectful in waiting to ensure that the sponsor of this bill had the opportunity to bring forward his amendments. And I believe the good senator from El Paso County spoke about a possible amendment. So I'm a little confused here. But if the amendments are the exact identical, then let me see the amendment. I'm happy to pull my amendment and discuss your amendment.
Any discussion on L008? Senator Van Winkle.
Thank you, Mr. Chair. And I do take issue with the bit saying there hasn't been communication on this topic of jurisdiction and who has authority, CBI or local law enforcement, because I know I, for one, have received hundreds of emails, texts, phone calls. There was testimony from local district attorneys. There was testimony from sheriffs that drove from all over the state of Colorado, came to committee and objected to this bill, largely not on the goals of the bill, but on how this bill affects the jurisdictional aspects of our Colorado law. Jurisdiction is very important to Colorado law. It's very important to all law across the nation, and it's been foundational to our United States. It's foundational to our state constitution and all state laws. What is for the young folks in school who are just here or who may be watching online, jurisdiction members is simply who has power in authority to administer justice. And two, there's two parts to it, that's all, is who is or what is the territory over which that authority can be exercised. So jurisdiction, of course, when we think of things like the state of Colorado can't go into Wyoming and shut down a gun show, or the folks of Wyoming can't come into Colorado and go to Fort Collins and shut down a dispensary. That's because of jurisdiction. Same goes for, especially goes for law enforcement, which is deeply rooted in all of our laws, deeply rooted in our Constitution. And once again, there is a command structure. There is a lot of training that goes on. And so to say hasn't been communication on that topic is frankly just absurd. Now, the amendment that passed in committee, I think does help, but the amendment itself actually references jurisdiction. It references that local law enforcement agencies and local district attorneys, it says in the jurisdiction where the Bureau is conducting investigations. So it actually acknowledges that local law enforcement and local DAs have that jurisdiction over that authority, but then it creates this 10-person task force that has no jurisdiction out within the borders of Colorado that can go anywhere and do anything, and all they have to do is simply communicate, reasonably communicate. That upends the structure of the way the Colorado Bureau of Investigation, the way law enforcement goes back to Old West days with the local sheriffs. and I urge a yes vote on this amendment. It is a very good amendment, and it returns the balance to the bill that has been longstanding since the foundation of our state.
Senator Pelton B.
Thank you, Mr. Chair. I like this amendment, and I hope that the amendment from the good senator from Centennial is going to offer something along the same lines, where it says that you must obtain consent. Consent from the local jurisdiction. The local jurisdiction that I elect in Logan County. You have to obtain consent, like this amendment says. I want my sheriff that I elect to do these investigations first. I want them to have the first right in refusal. I want them to have that because that sheriff represents me. And that's why I think this amendment is so important to this. Because, you know, we've had several sheriff's races in my community, and there's one guy that keeps winning, and he does an excellent job at representing me and representing my community. And that's the people that need to be the investigations first. And if they can't do it because they have a lack of people to do it, then they can give consent to the CBI. But on this amendment, I ask for an aye vote.
Mr. Minority Leader.
Thank you, Mr. Chair. I rise in support of Amendment 8 to Senate Bill 3. This amendment, and I'm going to argue two aspects of this. This amendment first seeks to make sure that we're being efficient, orderly, effective in law enforcement in Colorado. That is the purpose of the amendment, and I think it's meaningful, and I'll walk through a number of reasons why that is important that we do it, that we adopt the amendment, and the benefits we'll get from having done that. The second reason I rise in support of the amendment, and you've heard now from the bill sponsor his opposition to the amendment, is it identifies clearly what for some of us is the worst concern of Senate Bill 3, and that is the expansion of a statewide police force with specific initiatives and efforts that may be in contradiction to the broader state law and certainly local tradition. So, to the efficiencies question, the American tradition of authority and law enforcement has a rich, deep history that relies on county sheriffs, and it's rooted in the country's history, and it came from our origination from English common law, the system which was brought over, of course, by early settlers. This system established the sheriff as the primary enforcer of law in county jurisdictions, and there's reasons why this tradition exists. The practice has been maintained and evolved over the centuries, and the tradition is long and strong due to several key factors. The first is, just as I'd mentioned, this historical nature. The role of the sheriff as the county's chief law enforcement officer has a long history dating back to the colonial era. The tradition has been embedded in the structure. This is why it's important. It's embedded in the structure of local governance and law enforcement, providing a sense of continuity and stability, which is what we always want from law enforcement. Think about this. When we have challenges with law enforcement, it's typically because someone associated with law enforcement has stepped out of bounds. They've lost connection with that continuity and that stability, that relationship between the people responsible for enforcing the law and the community that they support by enforcing that law. The county sheriffs, I would argue, are among the most effective, and I'm a kid again from rural Nebraska, where we really relied on, understood, were connected with, and knew our county sheriff's office and deputies well. Some of us probably more than we should have, but the reality is we knew them well as a supporter and a member of the community. Which brings me to my second point of why this amendment's necessary and why it's important for us to support the county sheriffs in their authority. They are locally elected. These people are led by individuals who are meaningfully connected to their community by election. The people of the community say, that's my sheriff. That's the person that I have raised up by the electoral process and want to represent me in enforcing the laws of our community and the laws of the state, quite frankly. They do that very well as well. The direct line of accountability between the local residents and the electeds fosters this sense of community that I mentioned earlier. And that is a piece, when you think about some of the turmoil and turbulence we've had in our state and across the nation over the last several years, it's been because there was turbulence and disconnection between those enforcing the law and the communities with whom they worked to enforce the laws. Another reason that this is Amendment 8 should be supported is with local law enforcement, which Amendment 8 provides accountability, it provides connection. It says, don't intrude into and create confusion in law enforcement. Speak with us first. Let us know what's going on, and with our permission, we can engage together, say the local law enforcement, to others who might come in seeking to enforce laws. Speak with us so that we know what's going on in our community, and we can therefore provide better law enforcement. The county sheriff's departments are more flexible and adaptable to the specific needs and issues of the local communities. And so this amendment says, connect with us. We're maybe already on the case, and you ought to check with us before you intrude into our jurisdiction as we seek to enforce together the laws of the state. So one of the challenges that I think the bill more broadly brings, and this amendment would clean up, is this idea of jurisdictional conflicts. Conflicts can arise over jurisdictional boundaries, and I think they would be abundant, manifest, and frequent with Senate Bill 3, leading to confusion, inefficiency, and sometimes conflict between the law enforcement agencies. And what this does then is it makes the investigations less effective. The whole point of what we're trying to do, enforce the law, becomes confused and less effective. You can have different, not at the law level, not at the level of law, but at the level of policy and priorities, you can have differences in policies and priorities. You got CBI rushing in with this new police force, seeking to do something in a way, we're talking policy here, that is in conflict with the way that the local law enforcement might be, in fact, seeking to manage their workforce, manage their team, manage the investigation. We seek this kind of evidence first. We provide protection of evidence in this particular way. It could potentially upend those sorts of things, leading to less effective law enforcement. You've got one office, the local sheriff's office, handles evidence in a specific way to have success at trial. And then you've got CBI coming in and they handle the evidence in a different way, which causes a problem potentially in the chain of custody or the way the evidence gets handled in a way that creates confusion and less likely to be successful in actually enforcing the law. An important thing, and I will, when we get to the bill, actually talk about this more broadly, we've got our own policy problem, we've got our own process problem where we're running a big, expensive $2 million bill before we actually know whether we have the money to do it or not. We're pushing it through, jamming it through before we've even decided at the appropriations level whether we've truly got the money to do this or not. Not going to talk about that right now. I'll talk about that more when we get to the bill. But there is in this, as resolved by Amendment 8 to Senate Bill 1, there is duplication and potential waste of the taxpayers' dollars. You potentially got two groups spending money, team, staff, law enforcement, technology, and when you read the bill and when you read into the fiscal note, we're talking additional vehicles, additional, all the supporting elements that you need for law enforcement to do the work. It creates additional expense that is now potentially, probably, I would say, duplicated. And so we're wasting taxpayer dollars in the process of doing that. But I think probably I want to come back to the theme, this idea that community trust and community relationships in the enforcement of the laws is critically important. And that's really what Senate Bill, or Amendment 8 to Senate Bill 3 is all about. Local sheriffs often have strong relationships with their communities built on trust, familiarity. It's, you know, it's potentially somebody you grew up with who's now a deputy in the sheriff's office doing the work of enforcing the law, seeking engagement from the community, and therefore providing protection to that very same community. The intrusion of state, or potentially, you know, one step leads to another. We've got a state intrusion potentially here. Next thing you know, you're going to have a federal intrusion. Okay, I'm shadow boxing here. I acknowledge that. It can be disruptive to those local relationships, especially if the external agencies are perceived by the law enforcement themselves and the community at large to be intruding into the community, overstepping their authorities, and creating problems. So all of those challenges I've just mapped out, I think we wipe them away. We have the ability to better enforce the law if we accept Amendment 8. Now, the second argument, that was just the first argument. The second argument susses out, what is this bill really about? If the bill's about effectively enforcing the laws, then the Amendment 8 that says let's put things in alignment, let's make sure that as CBI comes in, that they are in alignment with, fully permissed, completely allowed to participate in the process by the local law enforcement, then, and only then, they can begin to participate in the investigation, the local matters, or the investigation at the local matter. If you reject this amendment, kind of tells you what the bill's about. It's about creating a stronger, more overreaching, I would argue, potentially, but we legislate in bands. Best case possible outcome, worst case possible outcome. On the worst case possible outcome side of this, 11 new members of CBI, Colorado Bureau of Investigation, investigating whatever kinds of crimes, becomes 22 members of CBI investigating whatever types of crimes. Becomes 88, becomes 164. It just grows and grows and grows. That's the worst case scenario. Best case scenario, yeah, works out. They actually call, they actually engage in a proper way. But the reality is, you can't depend on that unless you legislate that, and that's what Amendment 8 does. It says, don't intrude, seek first to participate in cooperation with the local law enforcement before you move in. So, colleagues, I urge your support of Amendment 8 to Senate Bill 1 based on the preceding arguments. Thank you very much, Mr. Chair.
Senator Pelton R.
Thank you, Mr. Chair. When I was county commissioner, some of my biggest fights, arguments, you name it, in meetings came with my local sheriff. But at the end of the day, I was very thankful we had them, and I was very thankful they had the power that they do. There's things arise and things that may arise that they need that kind of authority. We've had some issues in our county. The sheriff has asked CBI to come in. That's the way it needs to happen. They need to have the full cooperation and permission from the local sheriff to come into that jurisdiction and help with the investigation. That's the other help. Anytime we give a state agency priority and authority over the local government, the local authority, the sheriff, we're asking for trouble. This country was founded on the authority being closest to the people, being elected, not appointed, not hired, but elected. I support this amendment fully because it puts that priority in order the way it should be. The locals are the ones that need to have the say on when CBI gets involved, and CBI needs to have their permission to come in and conduct that investigation. So I like Amendment 008, and I'd ask that you'd be a yes vote.
Senator Will.
Thank you, Mr. Chair, and I rise in strong support of L008, and let me explain why. You know, prior to the beginning of an investigation, the Bureau shall request and obtain consent. That's because you can really goof things up, and I'm thinking of undercover situations. There's always, in these counties and places, there's always ongoing investigations. There can be undercover officers, working individuals. Sometimes what CBI might be investigating, which is highly likely, is these aren't the pillars of the community, right? So they're probably being investigated for other things and other crimes. If you don't collaborate and cooperate with the local authorities, you could really goof up an investigation. You might come in and say, I need Joe Blow, we want to investigate him for this, and you can say, hold off. The locals can say, hold off, we got this going or that going. So for that reason alone, I strongly, strongly support L008 so that there is prior consent before starting these investigations.
Senator Simpson.
Thank you, Mr. Chair. Colleagues, I rise in support of L008 as well. I think we're all in unison in trying to figure out a path forward that creates better outcomes for us in our communities. But creating this next level of oversight without this amendment and their ability to really engage more directly and potentially interfere in the possibilities of creating unsafe conditions is just a bridge too far for me. And thinking about how this amendment is constructed, which requires CBI upon consent from the local entities, is good governance. It's about how I would hope we could expect to have better outcomes and create safer communities and not put law enforcement, community, and/or CBI staff at risk potentially. It seems like a logical, sequential process in how we can, again, create better outcomes and safer communities for all of Colorado. I can't say enough how strongly I support L008. Thank you, Mr. Chair.
The motion is the adoption of Amendment L008 to Senate Bill 3. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L008 is lost. Senator Sullivan.
Thank you, Mr. Chair. I move Senate Bill 003, Amendment L004, and ask that it be read.
There is an amendment at the desk. Will the clerk please read L004?
L004.
Senator Sullivan. And please
Thank you, Mr. Chair. This one here, I'm not quite sure that I used the word similar, but tomorrow when I'm sitting in the garage listening to this all over again, I will look to see if that is what I said. But what this
and Senator Sullivan, one more time. I'm so sorry. Please move the bill now that we've had it read. Move the amendment now that we've had it read.
I move Amendment L004.
Thank you very much. Senator Sullivan to the amendment.
Thank you, Mr. Chair. And again, in this one here, this was this directly, and I did use the word directly. I believe this works with the conversations that we were just having with the word conflict. We have been talking with sheriffs. We have been talking with law enforcement. We have been talking with the district attorneys. And this would be an instance where, as we came up with a scenario, that there might be a sting operation or something going on an individual who had illegally tried to purchase a firearm. And CBI became aware of that from the local law enforcement or sheriff's office. They would not get themselves involved. And so with that, I ask for an aye on L004.
Senator Smallwood.
Thank you, Mr. Chair, and I appreciate the amendment from the bill sponsor. One clarifying question, obviously not having been involved in any of the conversations with the stakeholders, particularly the local law enforcement members, I wonder if we could go into a little bit what the commonly accepted practices would look like from the eyes of local law enforcement. And candidly, I don't know if there is a set procedure or a definition of commonly accepted practices, but the last thing I would want to see is CBI and a local sheriff's office or a local police department having a disagreement over what is commonly accepted as far as the practices are concerned. I would appreciate any further detail on that.
Senator Gonzalez.
Thank you, Mr. Chair. I rise in support of L004 because the hearing that we heard, where we heard testimony from law enforcement, certain law enforcement officials, certainly not all law enforcement officials, but it's my belief that this addresses the concerns that were raised. And so grateful and appreciative to CBI and local law enforcement for bringing forward this amendment to address and clarify the processes that they would enact. And so I do rise and ask for an aye vote on L004.
Discussion on L004. Senator Kirkmeyer.
Thank you, Mr. Chair. I just want to say, nope, not even close. I've been in constant communication with my sheriff this morning, and this isn't even close. It's also not even close and probably still in conflict, in my opinion, with the current statute. My sheriff in Will County, and he's been in contact with the other sheriffs throughout the state, again, just not even close. My amendment was what the sheriffs want. And quite frankly, I've been informed that basically the Speaker of the House is going to carry the amendment, apparently. So my amendment would have said what is consistent in law, that you have to, either the local law enforcement agency has to request, or there has to be consent. This amendment says, shall communicate. Again, no idea what that means. I mean, I have an idea what shall communicate means in normal terminology. I know that I'm communicating right now. But I don't know what it means when it says, the Bureau shall communicate with the appropriate local law enforcement agency. In what manner? So we took out the word reasonably communicate. We took out reasonably now. Now we're just going to say they shall communicate, and it's a shall. That's wonderful. They shall communicate by what? Telephone? Email? Text message? Actually talk to the person in charge of the investigation? Do they have to communicate to the sheriff? Do they communicate to the police chief? Who exactly are they communicating to? That's how broad this language is and how unacceptable it is. That's the first part. The Bureau shall communicate with the appropriate local law enforcement agency and deconflict in investigative operations. And how are they going to deconflict an investigative operation when the rest of the sentence says, prior to taking investigative or enforcement action? What if the sheriff or the police chief doesn't agree that you're deconflicting? Does deconflicting mean you stand down because the sheriff's got this? Is that deconflicting? What exactly does that mean with regard to this statute? Very broad language. They shall communicate and they shall deconflict investigative operations through commonly accepted practices. So I'm thinking the commonly accepted practice is that if you're jumping into someone else's jurisdiction, that you deconflict by stepping down, by standing down. That in other words, you should have just actually requested and gotten their consent, or they should have requested your assistance. This is exactly what we're worried about. That the true meaning of this law, regardless of what's been said, is that essentially we're trying to create a state police law enforcement agency that would have jurisdiction throughout the entire state by simply saying, oh, well, You just got to go communicate, and then you have to deconflict through commonly accepted practices. I guess that's their commonly accepted practice, prior to taking investigative or enforcement action. Prior to taking investigative or enforcement action. It doesn't say that you're not going to. It says you just have to deconflict it. So it doesn't mean you're standing down. So the real reason behind this bill is we're trying to create a state police law enforcement agency. Folks, I've got news for you. We don't have enough money in the budget to do that. Law enforcement agencies, in case for those of you who have not been in local government, the public safety component of a local government's budget is typically anywhere from 45 to 55% of it. They take up half of the resources typically that come into a local government to provide law enforcement agencies, to provide law enforcement. Half. So we don't have enough money to create a state police law enforcement agency. This amendment actually makes the bill worse. It does not improve it. It does not get to where the Sheriff's Association has asked for. I haven't talked to the police chiefs, but this is not where the Sheriff's Office, this is not what they asked for. They asked that you request, that the CBI has to request, or that the Sheriff's Office would request assistance prior to anyone entering into their jurisdiction. That's how it works between sheriffs and municipalities. The sheriff just doesn't go running into the city of Greeley or the town of Loch Bowie's jurisdiction. He can't do that. And he doesn't do that, and he doesn't expect to do that. So local law enforcement have it figured out. They request assistance. They work together. They partner. They know what the situational awareness is. They know how things are working and what they're trying to accomplish. This just makes the bill worse. Does not get to what the Sheriff's Association was asking for. Not even close. I ask for a no vote on L004.
Senator Rich.
Thank you, Mr. Chair. And like I said earlier, my sheriff is very much aware that we're talking about this right now. And he has seen the language of this amendment. I would have to agree with my colleague from the good senator from Brighton that this does not get close to what the sheriffs were asking for. He said this does not satisfy the sheriffs. So I don't know if a vote has been taken in the Sheriff's Association, but he talks to other sheriffs as well, and this is absolutely going to make the bill much worse. I ask for a no vote.
Senator Van Winkle.
Thank you, Mr. Chair. And I echo those sentiments because it actually raises even more questions and confusion about the bill, because right now the bill says the Bureau shall reasonably communicate. This changes it to just shall communicate. It doesn't define that. But more disturbing, I suppose, is they shall also work with the appropriate local law enforcement agency and deconflict investigative operations. Now, that raises a very serious and a very, very real-world possibility that faces Colorado in the near future upon the passage of this bill, if it is to pass. What if there is a conflicting view of how an investigation is being done? Or what if there is a conflicting view of what investigations need to be conducted at all? Long-standing tradition in the state of Colorado has been the authority lies with your locally elected sheriff and local police force. Which brings us full circle once again to we're creating for the first time a 10-person state law enforcement agency that has very few limitations. And so while it almost reads almost exactly the way the bill reads now, I'm not entirely sure what it does, although I do believe it will bring further confusion, especially if there is disagreement between a local sheriff and a member of this task force.
Any further discussion on L004? Seeing none, the motion is the adoption of L004. All those in favor say aye. Aye. Opposed, no. No. The ayes have it. L004 is adopted. Senator Marchman to the bill.
Thank you, Mr. Chair. So we've heard that we have thousands of denials and only a handful of investigations. So I just want to applaud the local law enforcement officers who have been successful in the handful of investigations. But I also want to acknowledge that sometimes more help is needed. And that's where SB 3 comes in. SB 3 authorizes state CBI to collaborate with local LEOs to investigate illegal firearm activity. If $1.4 million to CBI for 1 FTE and operating costs related to lab and investigative services saves 1 life, or 12 lives in a theater, or 5 lives in a club, or 10 lives at a grocery store, that's good enough for me. I want to share a story of a very sad death, 2 deaths that occurred in my town of Loveland in July of 2022. Police responded to a shooting in Loveland the afternoon of July 28. Officers found 41-year-old Lindsay and 16-year-old daughter Meadow dead. 4 children were rescued from that horror scene between the ages of 2 and 14. They are orphans now. Dom's and Sinner's deaths were ruled homicides by multiple gunshot wounds. Loveland police say the results of their preliminary investigation showed that the murderer reportedly purchased a firearm in March of 21 and was ordered but failed to relinquish it due to a protection order against him in Denver County in June. There's one local jurisdiction, Denver County. Dom filed a civil protection order against the murderer in September of 2021, naming herself and 3 of the kiddos in her house at the time of the shooting the protected parties. A temporary protection order was granted, but 4 weeks later, a judge denied a permanent protection order. Another protection order was issued against this man in November of 21 as a part of a criminal case. He was charged with sexual assault of a child, second-degree assault, misdemeanor child abuse, contributing to the delinquency of a minor, but there was no requirement that he had to relinquish any firearms, according to the Loveland police. But Denver County has also issued a protection order against him in November of 21 as part of the criminal case, which did require him to relinquish any firearms and wear a GPS ankle monitor. After he murdered his ex-girlfriend and her daughter, he went to Erie and he killed himself. And they found the Denver County GPS ankle monitor there in Erie. In January, the woman, Lindsay, called Loveland police to report that Acevedo violated the protection order against her children, but investigators found no criminal violations. 2 days later, a victim service coordinator contacted her with information about how to file a civil protection order. But friends, on July 26, 2 days before the shooting, Loveland police received a call from a concerned citizen who worked at Home Depot. And he ran into this guy who he'd used to work with, and CBS News Colorado filed an opens records request. In it, this is what this Home Depot Good Samaritan said. He said, well, he introduces himself. I haven't seen this guy in a couple years, the caller tells the police officer. The concerned citizen tells the officer almost immediately the conversation goes dark. He tells the guy at Home Depot his wife bleeped him over and he flashed an ankle monitor. And he said, I'm going to do life in prison, and I'm going to kill her, and I'm going to kill myself. He goes as far as offering up a time for when he may commit the murder. And he goes, I'm not doing it today. Maybe I'll do it tomorrow. The caller only knew the guy as his first name, where they worked together, but it was enough for the Loveland police to actually call and follow up. They said, hello, I'm calling you about some statements you might have been making today about your wife. The murderer says, about what? And the officer says, that you were going to harm her? And he says, oh, bleep no, dude. Why would I do that? It was a horrific call. 2 days later, he went and he murdered Lindsay and Meadow. And I'm going to share this because Meadow happened to be a friend of my daughter. She was 16 when she was murdered. And I remember my daughter coming to me and saying, Mom, something's happened. Meadow has died. And whereas my daughter, God willing, will be graduating with the rest of her friends in May, Meadow will not. So I'm going to speak a little bit about her. The 16-year-old victim, Meadow, was described as one of the most beautiful and vibrant souls we've ever met. She was brave, vulnerable, deeply in love with her family and her community. In fact, she put her body in between the shooter and her siblings and saved the life of one of her siblings that day. They set up a GoFundMe to support the 4 children, but she was a leader in the Colorado Youth Congress and was working on improving mental health support in schools in Loveland. Friends, SB3, had it been around, could have tied all the pieces together for all the jurisdictions where this murderer, who was not supposed to have had a weapon, could have had the weapon removed from him. So I very much support SB3 to save lives all across Colorado, and I urge your support.
Senator Van Winkle.
Well, thank you, Mr. Chair. And it's truly a heartbreaking story. I think of my 7-year-old little girl. And I want nothing but her safety. Unfortunately, the bill before us today, I'm not sure how it would help that situation. That horrendous story and that heinous criminal who was pure evil was under investigation, it appears. And there was a failure at some point to step in from either a court or local law enforcement agency. It sounds like a failure was in the court system where someone was asking for help and saying there is a threat against me. But I'm not sure these 10 officers who would be charged with beginning an investigation when there was already one there was already investigation underway would help. But if we could get back to just the text of the bill before us and the substance of the bill, there is one troubling part that we haven't addressed yet, and that is the fact that the bill right now says they can investigate throughout the state any criminal activity or suspected, it should be suspected, it's not, but suspected criminal activity involving firearms, described in Article 12 of Title 18. Now, that term involving firearms is very unspecified. I think I have an amendment here that hopefully we can all agree upon. And what it does is it specifies what that means involving firearms. And so, Mr. Chair, I submit L009.
There is an amendment at the desk. Will the clerk please read L009?
L009, amend the Judiciary
Senator
Committee
Van Winkle.
report.
Thank you, Mr. Chair, and I move L009.
To the amendment, Senator Van Winkle.
Thank you, Mr. Chair. And what this amendment does, it's relatively straightforward, but right now, again, in the bill, it just says any criminal activity involving firearms. And so under Title 12, or Article 12, Title 18. So what my amendment does is it takes the 8 specific crimes that are in Article 12, Title 18, and lays them out as to what they can do here. So the 8 crimes that this new 10-person task force, and 11 next year, will be able to investigate under this amendment, if adopted, are as follows, and I think it covers almost everything that anyone could imagine in terms of firearm law. The first is, what the sponsor himself has led with, both in committee and on the floor as a reasoning for the bill, is A, which is the unlawful purchase of a firearm in violation of Section 1812-111. So that's, again, if someone tries to purchase a firearm, they are denied. It turns out they've had a recent assault, or they are suspected of stalking, something like that. This 10-person task force could then launch into action and start investigating that. The second thing they can investigate is the unlawful private firearms transfer in violation, and all of these are clear to actually put chapter and verse, or in this case, the actual statutory reference. So the first thing, the unlawful purchase of a firearm. The second thing, the unlawful private transfer. So that's the case where if someone were to transfer to, say, a 15-year-old, or someone would transfer to someone suspected, again, of stalking or assault and battery, something like that. They're not a gun shop owner, but they transfer, they allow someone that shouldn't have a firearm to have a firearm, and they're the one that is the one to do that. Then this task force can go investigate that person. The third investigation they can launch is a violation in Section 1812-112.5 involving a firearm by a licensed dealer. So now we've got licensed dealers in there too. So maybe not a gun shop, maybe not just a private transfer, but a licensed dealer, someone perhaps at a gun show. Fourth, the unlawful delivering of a firearm in Section 1812-105. E, refusing to exhibit a record when requested by a police officer in violation of 1812-403. So that means if local law enforcement or a police officer is in a gun shop, asks for a record and they don't get it, then the CBI can come provide support under this law. And I believe they already can do that, but F, transferring a firearm at a gun show without the results of a background check. So that's if you're at a gun show or there's a big venue and you purchase a firearm, but they failed to do the background check, then it would be alerted in this new task force so that the CBI could come in and investigate that. Failure to maintain a record of background checks in violation of 1812-502. And these are all, again, existing crimes, and we're just specifying what it means to investigate something involving a firearm. In this case, it's failure to maintain records. So it's not that they're failing to produce it or they're refusing to produce it to a local law enforcement. It's that they just don't have the records that they're supposed to have in accordance with state law. And finally, failure to post a notice setting forth the requirements for background checks. So that's really what that is I think it's the last thing we could find in that subsection that wasn't already included. So we're trying to define the criminal activity, the suspected criminal activity that this new task force can do. It would have to fit into one of those 8 categories. They're very broad categories, and I can't frankly imagine a reason why this wouldn't be passed, because I can't imagine many crimes involving a firearm that aren't already included here. So I ask for a yes vote so that we can define that term involving firearms by pointing towards 8 specific crimes that this new task force may be able to investigate once they are launched. Thank you, Mr. Chair.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote on L009.
Mr. Minority Leader.
Thank you very much, Mr. Chair. I rise in support of Amendment 9. I think this is thoughtful. It works through the details in a way that would, I believe, begin to craft more precise policy. I think this is good workmanship. And when I was a younger man, I could do more than one thing at a time. Now I'm only capable of doing one thing at a time. So I will continue to argue in favor of Amendment L009. I especially like the cleanup on Roman 2 to investigate with prior consent of local law enforcement agents. Again, prior consent, we've got the local law enforcement agency engaged. Any other criminal offense discovered during the investigation. That just makes a ton of sense to me. I think that's appropriately expansive to local law enforcement. If we could just get it hands to the right people, I think giving them the ability to follow up leads that may come out of it is critically important. And if for no other reason, I would urge your support of L09 based on that.
Any further discussion on L009? Senator Will.
Thank you, Mr. Chair, and I rise in strong support of this amendment, L009. I mean, it gives clear direction. It isn't may, or it leaves no question in anyone's mind. So this amendment's great. I think the paragraph 2 is perfect, what we've been asking for all morning here, and this is a great amendment, and I'd ask everyone to vote aye on it.
Further discussion on L009. Senator Van Winkle.
Thank you, Mr. Chair, and I do appreciate those comments. I know the sponsor of the legislation hinted that it's an unfriendly amendment and urged for a no vote, but no reason was given. And frankly, I can't imagine a reason why this shall not be accepted unless that term, activity involving a firearm, was chosen very specifically, that we ought not define what that means. It makes me feel as if there's something that I'm not seeing in the text of this bill, but it makes all sense to me that we ought to define the crimes that this new task force should have authority over. And then again, as was mentioned by the good senator from El Paso County, that there is a catch-all there at the bottom that says they may also investigate with prior consent of local law enforcement any other criminal offense discovered in the investigation. So they aren't necessarily limited. If they look into one of these 8 things, someone purchases a firearm they ought not have, they fail their background check, or any of the other 7 things in this, if there's something beyond it, above and beyond that, they can simply go to local law enforcement and say, we found that there's more to this investigation that warrants further investigation, and they have full authority to do so. And so I ask for a yes vote because words have meaning, and that term right now is very, very broad and undefined. And if we're going to create a new statewide task force, a new statewide police force that has huge autonomy and can even trump the local control, they ought to at least have some guardrails over what their duties ought to be. So I ask for a yes vote, Mr. Chairman.
Seeing no further discussion, the motion is the adoption of L009. All in favor, say aye. Aye. All opposed, no. No. The noes have it, and Amendment L009 is lost. To the bill, Senator Van Winkle.
Thank you, Mr. Chair. Switch chairs on me.
There is an amendment at the desk. Mr. Hubler, will you please read Amendment L010?
L010, amend the Appropriations
Senator Van
Committee.
Winkle.
Thank you, Mr. Chair. I move L010.
To the amendment.
Thank you, Mr. Chair. And what this amendment does very clearly is in the bill right now, there's an appropriations section here that I will find the appropriation. There. It was put on in the appropriations, and what it allows for is it allows for nearly $1.5 million to the Department of Public Safety. And in that, there are 3 pieces. There is almost 407. I'm just going to round numbers here for the listening audience at home. There's $47,000 for use by the executive director or office to lease new space. So they're expanding their office space. They're going to find 10 new cubicles, offices, what have you. This amendment does not touch that. B, it allows for $351,000 for use by the Colorado Bureau of Investigation for operating costs related to laboratory and investigative services. So they're beefing up their labs, they're beefing up all the equipment, the things that a law enforcement officer would need to have to go along with an investigation. This amendment does not touch that. The one thing it does touch is the bulk of the appropriation, which is currently about is at $1.79 million this year, and it's for the hiring of 10 new FTEs in order to be this statewide, I'll call them, it's been called police force, I'll call them the statewide task force on guns or gun crimes. And what my amendment does is it takes that one section, not all three, just the one, and it takes it from actually it's not 1.79, it is $1.477 million. And what I'm doing is I'm cutting that in half. Oh, that's the overall. I'm cutting the 1.79 million in half to 5.39678, $539,678. So that's half. And then instead of 10 FTEs for the 10-member statewide police force, it makes it 5. And the reasoning behind this is very clear. We've never had anything like this in the history of Colorado. We don't know exactly how it's going to work. I suspect, just like all government programs, it starts with 10, and next year will be 20, and the year after that will be 50. We don't know, but if we're going to start this out, essentially, let's start with a reasonable amount, and let's see what the needs are. We don't know what the needs are right now because, as we have heard from the bill's sponsor, some very good facts as to how many denials there are. In fact, in 2022, there were 6,777 firearm applications that came back negative and came back denied, saying so-and-so is at a gun show, they were at a gun store, they're trying to transfer from an uncle to a cousin, something like that. It was denied. Among those, I know 116 were for a violent crime in a person's past, and those ought to be investigated. What we don't know right now, because local sheriffs are taking care, and local police right now have that authority. They're looking into this. So we don't know if 5 people are needed, we don't know if 10 people are needed, we don't know if 20 people are needed. So my proposal for this year's budget is to limit it to $539,678, $678. And instead of having a 10-person statewide police force, statewide task force that's never been done or tried before, that has authority over local governments, has authority over local sheriffs, we start with 5, see if it's even necessary to have this office at all, and if it is, then find out what the proper requirements are, because if they open up office and they just get flooded with local requests, which is already currently the law, if this was necessary, if local sheriffs were flooding CBI with local requests, we could simply give CBI more resources. I suspect they're not, and I suspect that there are very few sheriffs in the state of Colorado that would like to see a 10-person task force, a 10-person statewide police force. And so if we're going to pass this bill, I say we start out a bit smaller and start out with a 5-person task force. I ask for a yes vote.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote on L0 The amount of people that are in there and the cost and how the makeup was going to be has been an ongoing discussion with the head of CBI, with local law enforcement, with the governor's office. And this is the figure that they came up with, was having 10 people to cover the entire state. And I think we'd be doing a disservice to the people of the state of Colorado if we tried to do it on the cheap and did it, halfway. So I ask for a no.
The motion is the adoption of Amendment L010. All in favor, say aye. Aye. All opposed, no. No. The noes have it, and L10 is lost. Senator Van Winkle.
Thank you, Mr. Chair. And just simply to the bill, no amendment here. I do believe, upon the failure of that bill, that this is essentially $1.5 million of hard-earned taxpayer dollars that is going to regulate or create additional regulation, create additional checks and balances on already the most regulated industry in the United States. At this very moment, just to open a single gun shop, one must pay for a license, thousands of dollars in legal fees, and undergo regular checks from the ATF. And the ATF oftentimes will come into gun stores and shops, which is and even undercover. So it is quite surprising to hear that there are gun shops that are in violation of state law, because the ATF is already heavily investigating these gun shops. And additional checks, well, my greatest fear with the bill is that there is no due process protections for those who are being investigated by the CBI, and that local control, that local sheriff, the local police department, once again, is having their authority turned upside down and losing their authority over their own jurisdiction that the Constitution and the longstanding laws of Colorado have granted them. I ask for a no vote on the bill.
Minority Leader Lundin.
Thank you very much, Mr. Chair. I opposed the bill on policy, but have made elements of that argument during the course of discussion around some of the amendments. Right now, I just want to call out kind of what I describe as a process failure. And this bill is not alone in the process failure. We're pushing this bill through that is $1.6 million this year, $1.6 million next year, 10 FTE this year, 10 full-time equivalent individuals this year, 11 next year, without having really developed a budget to know whether we're going to afford it or not. And so this is a broader process argument that we really ought to get the budget closed out, figure out whether this is available, there's funds available for this in the budget or not before we push this policy forward. So I would just say we've got the cart in front of the horse. That poor horse's nose is getting rubbed raw by the fact that it's having to push this cart. We should get the budget figured out before we commit another $1.7 million, give or take, this year and next year to the effort. So that is my final argument on the bill. I urge your opposition to Senate Bill 3 and appreciate the conversations, the debate, and I always am grateful for everyone having an opportunity to bring their perspective into the conversation. We clearly have some colliding perspectives and disagreements about how we would go after achieving these sorts of things. As you recall, I argued on behalf of, quite frankly, a little bit of expanded law enforcement authority with regard to one of the amendments that was rejected by the bill sponsor. I believe that law enforcement authority, when in the hands of the appropriate jurisdiction, is absolutely the way to move forward. Unfortunately, I don't see that 003 gets us there. Thank you very much, Mr. Chair.
Senator Sullivan.
Thank you, Mr. Chair, and thank you, everybody, for being involved in this lively conversation. I, of course, ask for your support on this, and was again reiterated to me last night. My mother, or my wife, was at the grocery store and saw a woman that she was and that they had been seeing each other in the grocery store several times, and they kind of looked familiar to one another. And the woman finally said to my wife, do I know you? And they got talking. Ended up that this woman was the mother of one of my daughter's teammates on a Pee Wee soccer team, and she recognized her. And so they could remember about what they had been. And so she remembered my daughter, Megan, and then she, of course, said, and we know all about Alex. And we're so sorry about, what has happened to your family these last, going on 12 years. But then she went on to say, we are so supportive, and every time we see your husband, in the newspaper or on TV or something, we're so proud of him, and we appreciate what he does and how he stands up for all of us here across the state in fighting this public health crisis that is gun violence. So that's the reason why I stand here. It's for those people who haven't been heard, those people who have been impacted. I mean, quite frankly, this is a piece of legislation, as I have heard time and time again. Don't create new legislation, just enforce the stuff that you already have. That's what this is exactly doing. It's enforcing people who have gone through the system. Someone should have been working on this any of the years in the past 10 years since this bill and this legislation was passed. It didn't happen, but with the passage of this, we are on the way to doing what needed to be done. And again, I ask for your support on this Bill 003.
Senator Kirkmeyer.
Thank you, Mr. Chair. Folks, had my amendment passed, I would have voted for this bill. Senate Bill 3, if the Colorado Bureau of Investigation would have been required to request and get consent from the local law enforcement agencies to enter into an investigation, I would have been a yes. I didn't hear anybody say, don't go and enforce the law. I didn't hear anyone say that we shouldn't have partnerships, that we all shouldn't assist each other. I mean, aren't we on the same side? I didn't hear say, oh my God, CBI shouldn't go help the sheriff or help the local police in an investigation. I said, don't go mess one up. Don't go mess up an investigation by stomping all over someone else's jurisdiction. Don't go create a state law enforcement agency when we don't need one. They want to partner, they want to request, get consent, and go join in on an investigation, by all means, go do it. That's what mutual aid is about, folks. That is what mutual aid is about. What I said was, don't go tripping into a situation that you don't know the whole situational awareness, that you may put lives in danger, that you may screw up an investigation, screw up a much larger investigation. That's what I said. That's what my amendment would have done. By all means, law enforcement agencies should all work together to enforce the law. No one said differently. This bill now, with the amendment, is actually worse than when we started. Is actually worse than when we started. We went from shall reasonably communicate to just shall communicate. So we don't know what reasonably communicate means, so we'll just wipe that out and we'll just say they just got to communicate. We don't know what that means. We went to, they've got to deconflict. What? Using best practices. What? How about you just, as a CBI, as the state, how about you just not enter into someone else's jurisdiction without them either requesting it or without you requesting consent? It's not that hard. Fire districts, law enforcement districts, the sheriff, they all have mutual aid agreements. There's no reason why the CBI couldn't have put in a mutual aid agreement and said under certain circumstances, we're going to provide mutual aid. Oh, wait, the sheriff didn't ask for it. Instead, we're just going to jump into their jurisdiction and mess things up. If we're truly trying to get better enforcement of the law, We should require everyone to work together, not supersede the sheriff's jurisdiction or the police chief's jurisdiction in his own municipality. That's when conflicts arise. Why did we need an amendment to say you got to deconflict? Because you don't want them to conflict. This bill's worse now. This is not what the sheriffs asked for. They said, hey, look, we work with the CBI all the time, and they do. You just need a request. You need to let us know you're coming into our jurisdiction. Not just blow into town and blow up and mess up our investigation. Not just come in and take away their jurisdiction. That's not what the CBI is supposed to be doing. And there were at least 4 examples in current law where we told them they had a request. Why is this one different? 4 examples in current law. The very first thing underneath the duties of the Bureau of Investigation, the Criminal Bureau of Investigation, is that if they are going to enter into someone else's jurisdiction, they have to be requested to do so. It's about saving lives. It's about enforcing the law and getting things done right. I urge a no vote on Senate Bill 3.
Senator Pelton R.
Thank you, Mr. Chair. I too urge a no vote. Our sheriffs already work a lot with CBI when they need the help. They can do a lot on their own. I think this bill is not giving our sheriffs the credit they're due. I see this bill as another overreach of a state agency being able to just come in and take over something they shouldn't be doing unless they're asked to be there. I see it growing another state agency. When is this government growth going to stop? I see this bill as unneeded and overreaching. I urge a no vote.
The motion is the adoption of Senate Bill 003. All in favor say aye. Aye. All opposed, no. No. The ayes have it, and Senate Bill 003 is adopted. Mr. Hubler, will you please read the title to Senate Bill 150?
Senate Bill 150 by Senator Cutter and Representative Froelich, concerning requirements for the processing of municipal solid waste in the state.
Senator Cutter.
Thank you, Mr. Chair. I'd like to move Senate Bill 150 and the T&E committee report.
To the committee report.
So what we did in committee was just, at the request of CDPHE, we added some exemptions to the bill, avoiding impacting facilities, using paralysis for allowable activities, including law enforcement, evidence destruction, medical waste, and crematoriums.
Any further discussion on the committee report? Seeing none, the motion is the adoption of the Transportation and Energy Committee report. All in favor say aye.
Aye.
All opposed, no. The ayes have it, and the Transportation and Energy Committee report is adopted. To the bill. Senator Cutter.
I'd like to move Senate Bill 150.
Discussion on Senate Bill 150.
I did.
There is an amendment. At the desk, Mr. Hubler, will you please read Senate Bill, or Amendment L004?
L004, amend printed bill, page 2, line 21, strike definitions and substitute definitions rules. Amend the Transportation and Energy Committee report dated February 28, 2024, page 2, line 14, after incinerator, insert or. Page 2 of the report, strike lines 15 through 20 and substitute paren 6 biomass boilers, firing materials listed in 40 CFR 60.288, parens B, parens 1, 2 parens B, parens 4, or other approved fuels. Page 4 of the bill, after line 18, insert parens 4. Nothing in this section prohibits the burning of waste tires or tire-derived products as fuel in cement kilns. Parens 5, the Commission may adopt rules to enforce this section.
Senator Cutter.
Thank you, Mr. Chair. So L004 is per the request of CDPHE, and this amendment makes the verbiage about waste tires consistent with the existing statute and the waste tire bill and adds an exemption for biomass boilers, and we would ask for your support.
Further discussion on L004. Seeing none, the motion is the adoption of L004. All in favor say aye.
Aye.
All opposed? The ayes have it, and L004 is adopted. To the bill, Senator Michelson-Janae. Oh, there is another amendment at the desk. Mr. Hubler, will you please read Amendment L007?
L007, amend per the bill, page 4, line 20, strike portion and repeal parens 1, parens A, parens 5, and substitute portion. Page 5, line 13, after neutral, insert synthetic gas produced by pyrolysis.
Senator Cutter.
So L007 removes reference in this bill to Colorado's current statutory definition of pyrolysis. We had that in the bill originally, changing. We believe it deserves a real world definition that is consistent with federal interpretations of pyrolysis by acknowledging that some oxygen is actually present in the process, but we are no longer trying to update the statutory definitions through this bill so we can focus on the real reasons we're here, to prevent new sources of pollution in the form of waste incinerators and plastics to fuel facilities from coming to Colorado. So this was a point of some confusion, and we are taking it out and not touching any definitions, so we would ask for your support on this.
Seeing no further discussion, the motion is the adoption of L007. All in favor say aye.
Aye.
All opposed, no. The ayes have it, and L007 is adopted. Senator Michelson-Janae.
Thank you, Mr. Chair. Across the U.S., environmental regulations are being slashed to allow the conversion of waste and plastics into fuel. Municipal solid waste incineration, aka waste to energy, and plastics to fuel processes are harmful, false solutions to managing waste that only worsen the climate crisis and perpetuate natural resource extraction. Why should we not burn waste? 1, harmful impacts to human health. Plastics to fuel processes use and produce hazardous chemical and generate hazardous waste. Toxic pollutants and hazardous waste from municipal solid waste incineration and plastics to fuel facilities include dioxins, arsenic, mercury, and benzene, among many others. These toxins are correlated with health impacts including cancers, neurological disorders, heart problems, and reproductive, immune, and respiratory disorders. Disproportionate pollution in vulnerable communities. Nearly 80% of facilities that incinerate municipal solid waste, including the burning of plastics, are built in low-income and BIPOC communities. Think Commerce City. Colorado does not need any more processes that put fence-line communities at risk. Disrupting Colorado's circular economy. Municipal solid waste incineration and plastics to fuel processes destroy the value of extracted nature resources that could otherwise be conserved or recycled back into the supply chain. These practices perpetuate the need to continuously extract natural resources to financially sustain incinerators consuming valuable materials such as paper, cardboard, and some plastics that could otherwise be recycled or reduced altogether. It's never worth the cost. Municipal solid waste incineration and plastics to fuel projects are expensive approaches to waste management that nearly always rely on government investment of taxpayer dollars and/or tax incentives to build municipal solid waste incineration in the municipal solid waste incineration is the single most expensive method to manage waste and the second most expensive method of generating electricity.
Senator Cutter.
Thank you, Mr. Chair. Sometimes greenwashed under the guise of chemical, advanced, or molecular recycling, plastics to fuel processes are energy-intensive plastics conversion processes, pyrolysis, and gasification, and they're not worth the high environmental and economic costs. Only a very small percentage of plastics that go through these processes are actually recycled, and most of the outputs are used to create low-grade fuels. These processes are regulated as other solid waste incineration under the Clean Air Act. A report from National Renewable Energy Lab, NREL, and the Department of Energy last year found that the economic and environmental costs of turning old plastic into new using pyrolysis were 10 to 100 times higher than those of making new plastics from fossil fuel. We already have plenty of plastic and in some beneficial uses, but we do not need to perpetuate creating additional plastic. And I want to be clear as well, and plus, it's as you heard, it's very toxic and harmful to the environment and in the burning of it. There was something put out about Amendment L005, and I want to be super clear, that amendment is not running. So if you have an argument or something based on that, it's not part of the bill. So we are not running L005. And I also want to make sure that you all know we are working on a circular economy, on extended producer responsibility, which is should be starting any time now. They've been working hard on it. All of the materials that are going to be recycled through EPR can already be done via mechanical recycling. There's many, many things. You'll hear a little bit more about some of the many things that can be recycled or be created through plastics that are mechanically recycled without the danger of toxic fumes and harming marginalized communities.
Senator Priola.
Thank you, Mr. Chair. Members, I rise in support of Senate Bill 150. Tell you a couple of reasons why. A, being from Adams County, where a lot of burning has been gone on for decades, and we who live there deal with the health effects of it. This undermines what we've worked on for years, in a sense, the protecting the circular economy. Colorado is investing in developing a circular economy that will reduce toxins, pollution, and energy use by authentically recycling materials, including plastics and tires, into new products. Which reminds me, I should have my aide bring down some samples of some recycled tires I have in my office. Municipal solid waste incineration and plastics to fuel processes are the opposite of processes that benefit the circular economy, as they destroy the natural resources. These practices perpetuate the need to continually extract natural resources in order to provide fuel to sustain incinerators, which consume valuable materials that could otherwise be recycled or reduced altogether. A peer-reviewed report from the National Renewable Energy Lab and the Department of Energy found that the financial costs, greenhouse gas emissions, energy use, toxicity, land use, and water use of trying to make new plastics out of chemically derived from this pyrolysis of plastics are 10 to 100% times higher than producing chemically directly from fossil fuels. Pyrolysis and other plastic-to-fuel technology face the same challenges that mechanical recycling of plastics, including the need for large, substantial quantities of clean, non-contaminated, uniform resins. To date, most pyrolysis factories have targeted pre-consumer materials, which are prime targets for traditional mechanical recycling. And to back up and define pre-consumer materials, imagine your end product is made something out of a resin that you get sheets or so. In the process, you have waste. So that waste, the resin waste, is more easily recyclable, but it's being incinerated in many parts of the country. To build a truly circular economy in Colorado that minimizes waste and keeps natural resources in circulation for as long as possible, we need to develop a system that supports genuine recycling and pose minimal to no risk to the environment or public health. Let's continue to invest in the circular economy that will be good for the economy, the environment, and the people of Colorado. Again, I also want to speak to the point that we're struggling with air quality here along the Front Range with being out of compliance with the EPA and the SIP. Bringing in unproven industries that are not working around the rest of the country to try to get going, probably along the Front Range. Of course, that's where they'll do it because of the scale and the logistics and the infrastructure. That will only add to our problems with our air quality, in my estimation. So let other states be the guinea pigs. Let them try to work it out to get it, if it is possible, to get it below 10 to 100 times more use of energy and other inputs. We don't want Colorado to be the guinea pig for pyrolysis. I ask for an aye vote on Senate Bill 150.
Senator Pelton B.
Thank you, Mr. Chair. So one of the best things that I got to do as a county commissioner is I got to entertain new companies coming into our county, and this was one of them. We had two people actually come in and want to buy land that the county owned and be right next to our landfill. So we could divert some of the plastics that were coming from communities that were not recyclable. Because at the time, we were not putting it in the landfill because we were shipping it to Denver, which would then go on to China where they burned for electricity. Because that was our recycling program at the time. So now, what we were trying to do is we were trying to use it as a fuel. And when they brought it to us, we have these things called feed bags that are really thin plastic. If you see, we'll go in and we'll harvest corn or we'll harvest milo. And what the good senator from Douglas County says, the sorghum that we have in our community. And you'll see these big white bags along. Those bags cannot be recycled. They end up in our landfill. And it fills our landfill. If you're going to grow hemp, same thing, black plastic on the ground. And it prevents the weeds from growing up around it. So then you have, or vegetables, same way. You can have the vegetables in the same place. Will that use that black plastic? So we are looking forward to recycling that plastic and using it for fuel. Because again, like I said, in ag communities, that's what was going to happen. I looked it up on the USDA website, and they show that that ag plastic is part of biochar, that they can make biochar out of that ag plastic. So I'm gonna ask for an amendment.
There is an amendment at the desk. Will the clerk please read L009?
L009, amend printed bill.
Senator
page
Pelton
2.
B.
Thank you, Mr. Chair. I move L009.
To the amendment, Senator Pelton B.
Thank you, Mr. Chair. So what the amendment does is it makes the Department of Public Health and Environment, and they need to conduct a feasibility study of pyrolysis, and it needs to be done on or before January 1st, 2025. And the Department of Public Health and Environment shall submit a report of the findings and the study described in this subsection. So that's basically what I'm asking for, is like, if this is a feasible thing and our smaller communities can use it to prevent us from filling up our landfill, they have to go through the air quality permitting test. And I have to tell you, I was on the ozone committee this last summer, and I have to tell you, when CDPHE got in front of us, they said that we produce the cleanest energy in the United States. And so we would have to go through those same air permitting processes to be able to permit this type of technology. So I'm just asking that CDPHE perform this study to make sure that we can use this technology in the future. I just think it's a great idea to have this, And it's a great idea to move forward with this technology because it's hard for our small communities to come up with $30 million to create a new cell for a landfill. That's how much it's going to cost us. It's how much it's going to cost Logan County because our neighboring counties spent at least that much to be able to create a new cell. So every time that this plastic is used and it fills up our landfill, we need a place for this stuff to go. And this is non-recyclable plastic. And we use it in agriculture. So I just ask for an aye vote on L009.
Senator Cutter.
Thank you, Mr. Chair, and thank you, Senator Pelton. But respectfully, we've talked a little bit about what we're doing to divert trash in our state, and we are working very, very hard. There's processes in place right now and moving forward to eliminate so much trash from the landfill. So I'm really excited about that. So that is, generally speaking, that's something you and I agree about, and generally speaking, we're absolutely moving in the right direction. But we don't want to make the mistake of opening the door for technology, because we all know this, you'll appreciate this, once the horse is out of the barn, right? And there's once the horse is out of the barn, it's going to be way more difficult to actually stop technology that we know is bad. When businesses are there doing it, making money, needing more plastic, whatever it is, it's going to be way more difficult. We know that this is that the permitting process, we were on the same committee this summer, the permitting process is imperfect. And I'm not, I'm not confident that they could allow businesses to, move forward with these kinds of things that we think are harmful to the environment. Let's see, just another one just shut down. Another chemical recycling facility, pyrolysis facility in Oregon just closed. There's all over the world and all over the country, there's examples of these plants closing down because they have net energy loss. There are consistent operational problems and emissions violations. There's all kinds of examples. And all I'm saying is, at some point, maybe this would be an okay thing and we should look into it again, but right now the technology's not there, and I think it's really, really important to protect our communities and stop perpetuating the use of plastic. So I ask for a no vote on the amendment.
Any further discussion on L009? Seeing none, the motion is the adoption of L009. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L009 is lost. To the bill. Senator Hansen, there is an amendment at the desk. Will the clerk please read L011?
L011, amend the Transportation and Energy Committee report dated February 28, 2024, page 2, line 17, strike
Senator
1,
Hansen.
page 2.
Thank you, Mr. Chair. I move L011 to Senate Bill 150.
To the amendment, Senator Hansen.
Thank you, Mr. Chair. Members, L011 is an amendment focused on making sure that we don't restrict our technology options into the future. We've got a really important debate in this bill about waste incineration. I 100% support that. Senate Bill 150 is, I think, main purpose is focused on ending waste incineration in the state of Colorado. Very supportive of that. What I worry about, though, with the current version of the bill is that we will be excluding any future use of pyrolysis technology. And I think that would be a policy mistake for the state of Colorado. The way the bill is currently written, it references federal regulations that combine pyrolysis and combustion into the same definition. And that's really where we're getting tripped up here in the current version of Senate Bill 150. And L11 simply excludes pyrolysis that can create useful products. So I want to keep that as an option for the state and not have a bill that combines those two ideas of combustion and pyrolysis, because they're not the same thing. Combustion, you use oxygen to oxidize a fuel and combust it. Pyrolysis, very different process, and a set of processes that are evolving and changing as technology improves over time. So I'd like to keep that as an option for the state of Colorado. And keep in mind, any new project that were to come forward or be proposed or take advantage of any future technological advancements in this area would still have to get air permits. It would still have to go through federal and state processes, would still go through all the site reviews that we have for a new industrial facility. So none of those things go away. I just want to make sure we're not getting tripped up by the reference in the bill to a federal definition that lumps together both pyrolysis and combustion into the same idea. I think we need to keep those separate, and I urge the adoption of L011.
Senator Simpson.
Thank you, Mr. Chair. I rise in support of L011 as well. And really, the conversation around the bill is shutting down the potential use of technology that we're not using right now. This just assures us that we keep that option open and we don't shut the door on opportunities where pyrolysis is used in waste tires, in biochar, in biomass. It's referenced at least in, I think, 5 or 6 different titles of Colorado Revised Statutes. I think it's just vitally important for us. I know in an effort to create a truly circular economy, we want to shut the door on this potential and possibility, but doing that it's a little like going, we want to convert to all electric cars, so let's shut down oil and gas operations in Colorado. Oh, wait a minute, that's another bill at another time, but to the amendment, I am very supportive of Amendment L011. Thank you.
Any further discussion on L011? There's discussion on L011. Senator Cutter.
Thank you, Mr. Chair. As I said before, this is making room. I don't object. I want to be clear. I don't object to advancement and innovation, but we clearly know that it's not here right now, and the process is harmful and perpetuates the use of plastics and fossil fuels. It is not a perfect process. In fact, there's no such thing as zero oxygen. It is not a thing. That's not possible. So I would prefer to not overburden CDPHE with permitting requests and additional work to regulate these facilities when we actually know they're not useful. I have indicated a willingness to talk in the future as this bill moves forward to talk about ways we can put some guardrails around it and make sure that, that if certain criteria is met in the future with this process, that we would consider it. But right now, it's bad, and I think it's way more difficult to shut the door, to shut things down once we open the door and let it in. So I would please ask for your no vote on this amendment.
Senator Priola.
Thank you, Mr. Chair. Members, I asked for a no vote on this amendment, and I appreciate what the good senator from Denver is trying to do. And we usually agree on many things, but I actually had a title related to pyrolysis last year that I pulled. And then as I did further research and realizing how far away it was from actually being feasible, I killed the title before introducing anything because it doesn't pencil out. And I don't think it'll ever pencil out given how quickly renewable energy is falling in price and replacing fossil fuel. So also considering the fact that we have air quality issues in this state, especially across the Front Range, why would we waste our time and resources even considering attracting an industry that is decades or more away from being feasible to come here and incinerate things or melt things or however they want to couch it, when we have nation-leading legislation for circular economy that other states are copying, and this would undermine that. It just doesn't make policy sense for us as a body to adopt this amendment to undermine Senate Bill 150, that in my opinion is a bright line, an underline, an exclamation point on we are moving in the circular economy route in Colorado. If you want to experiment with burning things, go do it in your other state where you don't have the air quality issues we do in Colorado, where you don't appreciate the outdoors, where your tourism industry isn't tied to clean air and mountain vistas and so on and so forth. I ask for a no vote on this amendment.
Senator Hawkins Lewis.
Thank you, Mr. Chair. This is why this amendment is bad. Because these processes that this amendment would leave in the bill produce very hazardous chemicals. And that's what I wanted to talk with you about. Let's pick on one, just one of these chemicals, dioxin. It's related to cancers, neurologic disorders, heart problems, reproductive disorders, immune, respiratory. But let's really get to the bottom. Who is going to be impacted if we leave this amendment in the bill? 80% of waste incinerators and plastic-to-fuel facilities are located in low-income and BIPOC communities. My very own community in East Longmont, we have an old factory that has numerous fires. They have traced benzene. They have traced arsenic. They have huge traces of dioxin. Why would we want to allow these processes to impact the communities that already have a higher rate of these health disorders? Asthma, precancer. Let me just tell you just one of these chemicals, what it does to the body. First of all, dioxins take a long time to break down. Why is that? They accumulate in our fatty tissue. They accumulate in our liver. They don't go away because they're sitting there. They're lipophilic, if you want to get into some chemistry. They sit there in the bodies and they build up. That is why we cannot have these processes. That's why we can't have this amendment. That's why we can't do this in Colorado. We will be punishing the people that we're trying to impact. Please, colleagues, let's vote this amendment down. Let's pass the bill, but let's vote this amendment down.
Senator Simpson.
Thank you, Mr. Chair, and colleagues. Just for clarity, recognize we don't have any of these facilities yet. We actually could control where they went, the air permit requirements, and right now, potentially, if we ever got to that point, the materials that the plastics that they would want to burn are currently not recyclable. They end up someplace else with little to no control. They end up in a landfill, buried underground, where it's more difficult to trace and track what happens to those materials when they break down. Or alternatively, they end up being boxed up, loaded up, shipped somewhere else to probably be burned someplace else with either much less strict controls or none at all. That's why it's important we retain this ability to have oversight and control over the process going forward. Again, I offer support for L011.
Any further discussion for L011? Seeing none, a division has been requested.
Mr. Majority Leader. Are we good?
A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of Amendment L011 and Senate Bill 150. All those in favor, please stand. Please be seated. All those opposed, please stand. The chair is not in doubt. The motion for the adoption of Amendment L011 is passed. Adopted. To the bill. Any further discussion on Senate Bill 150? Senator Simpson.
Thank you, Mr. Chair. So again, colleagues, the nexus of the bill is to really stymie any innovation and potential for utilizing this technology somewhere in the future. I think about what would have happened if over time in history other states, other countries had taken kind of similar approaches about what we deem right now as really important renewable energy. Think about solar panels, recognizing what goes into the construction of a solar panel. It requires, among other things, silver, aluminum, copper, indium, cadmium, and tellurium in particular. Tellurium hit a chord with me because that's what the town of Telluride is named after, is tellurium. But those are all extractive industries that have an environmental footprint, have an impact on society, on our livelihoods across the spectrum. I think about tellurium in particular. Again, it's an extractive industry that then goes through some sort of process, sometimes smelting. It's intense, and I promise you in the beginning, it wasn't energy efficient to go through all this to create solar panels. Commercially, for tellurium, the primary use of tellurium is in solar panels and thermoelectric devices, a more traditional application in copper and steel alloys where tellurium improves machinability, also consumes a considerable portion of tellurium production. Tellurium is considered a technology-critical element. But I was going to touch base again. That was important in our development and knowledge and transition into a more renewable society. Most tellurium is obtained from porphyry copper deposits. Again, there's a hole in the ground somewhere. There's a hole in the ground somewhere, and an extractive industry is taking place to recover those deposits. It occurs in trace amounts. The element is recovered from anode sludges from the electrolytic refining of blister copper. It's a component of dust from blast furnaces, refining of lead. There's an exhaustive process to go through to get tellurium that we need to create solar panels. where would we be sitting today had other states, other countries banned this effort because of the environmental impact? And I promise you, in a number of those, they're in communities that disproportionately impacted communities as well. I just think it's too short-sighted to just go today, let's ban this technology, even though we're not using it yet anywhere, largely because it's probably not economical, it's not energy efficient, it doesn't work well. But let's not close the door on innovation to try to get us to that point. So I do have for discussion, if I can find my amendments.
There is an amendment at the desk. Will the clerk please read L008?
L008, amend printed bill, page 4, strike lines 19 through 27, strike page 5, page 6, strike lines 1 through 14, renumber succeeding section accordingly.
Senator Simpson.
Thank you, Mr. Chair. I move L008.
To the amendment, Senator Simpson.
So the amendment basically removes the conversation about eligible energy section effects. So it really strikes section 3, 4, and 5 of the bill. So it leaves the legislative declaration. It leaves in the prohibition of facilities that incinerate municipal solid waste. But what it does do is strikes section 3. Section 3 in Colorado Revised Statutes 42-124, amend 1A, introductory portion, and repeal 1A5 as follows. Renewable energy standards, qualifying retail and wholesale utilities, definitions, net metering, legislative declaration for rules. Each provider of retail electric service in the state of Colorado, other than amendment proposed to strike, that serve 40,000 customers or few is a qualifying retail utility. Each qualifying retail utility, with the exception of cooperative electric associations that have voted to exempt themselves from commission jurisdiction, this is the Public Utility Commission, pursuant to section 49.5104, and municipally owned utilities is subject to the rules established under this Article 2 by the Commission. No additional regulatory authority is provided to the Commission other than that specifically contained in this section. In accordance with Article 4 of Title 24, the Commission shall revise or clarify existing rules to establish the following: definitions of eligible energy resources that can be used to meet the standards. Eligible energy standards means recycled energy, renewable energy resources, and renewable energy storage. In addition, resources using coal mine methane, and then the introduced bill would strike, and synthetic gas produced by pyrolysis of waste materials are eligible energy resources if the Commission determines that the electricity generated by those resources is greenhouse gas neutral. The Commission shall determine, following an evidentiary hearing, the extent to which such electric generation technologies utilized in an optional pricing program may be used to comply with this standard. A fuel cell using hydrogen derived from an eligible energy resource is an eligible electric generation technology. Fossil and nuclear fuels and their derivatives are not eligible energy resources used in this section. And then it goes on again to strike section 4 and section 5. So I would ask for support of amendment L008 and the effects of removing that language about being it now it not being an eligible energy resource.
Any discussion on L008? Senator Cutter.
Thank you, Mr. Chair, and thank you to my colleague for the amendment, but I would ask for your no vote today.
Any further discussion on L008? Seeing none, the motion is the adoption of L008. All those in favor say aye.
Aye.
Opposed, no. No. The noes have it. L008 is lost. To the bill, Senator Simpson.
Thank you, Mr. Chair. So again, the idea of really suspending this technology and squelching any innovation about, again, how do you deal with these really hard to recycle plastics? And appreciate, I've been supportive of the concept of trying to get to a point where we minimize. Colorado's really lags in this space of being effective and participant in recycling programs. I lived in Australia in the outback for a couple of years and was amazed at how easy they made it for me to become a recycler. And I appreciate the efforts in doing this, but this bill and this attempt to squelch this technology, I think puts us in a bad spot. But if we're going to move forward with this bill as written,
There is an amendment at the desk. Will the clerk please read L010?
L010, amend printed bill, page 2, line 21, strike definitions and substitute definitions, sunset review, repeal. Page 4, after line 19, insert 4. The
Senator
section is
Simpson.
repealed.
thank you, Mr. Chair. I move L010 to Senate Bill 150.
To the amendment, Senator Simpson.
Thank you, Mr. Chair. So the concept here is if we're going to go down this path and take away this resource, this technology, this potential, after a period of years, effective September 1st, 2030, it gets repealed, and we do a review and analysis of where we're at today with the potential then, with the repeal in it, then it puts it back into place with the necessity of reviewing what has changed since the implementation of this new policy. So I encourage my colleagues to support L010 so we get an opportunity to reevaluate.
Senator Priola.
Yes, Mr. Chair, members, I asked for a no vote on L010. I kind of find it humorous that we're here debating and referring to as technology, basically Stone Age technology, which has been around since the beginning of man, of burning things. We are working on a circular economy in the state of Colorado, and if my colleague could grab one of those little rubber ingots off my desk, I would like to have distribute to any member that's interested. Right there, the round ones, right there. So tires are considered one of the most difficult things, or had been considered one of the most difficult things to recycle because on the molecular level, a tire is basically one giant molecule. But I took a tour of a plant called Pretread, and I have a number of these if you want you to take a look at them. But they've figured out a way to turn them into reusable products. They're creating something that would be a rubber version of a Jersey barrier. Hopefully it will be referred to as a Colorado barrier in the future. But this is true innovation. It doesn't require incinerating things like our ancestors tens of thousands of years ago did. It requires actual real science and creativity and ingenuity to turn waste products into new products, not just throwing them in a fire and burning them like our ancestors did 10,000 years ago. So I would simply ask for a no vote on L010.
Mr. Minority Leader.
Thank you very much, Mr. Chair. I rise in support of Amendment L010. It's interesting how, we in the policy space, we read white papers, we go to conferences, we take tours, and we learn things, and that's beneficial, and I'm grateful for all the learning opportunities. But my colleague from Alamosa has actually done the work in the field. He's got grit and dirt under his fingernails from having done the work. Kind of makes me think about how that sort of experience leads to incredible innovation, leads to, well, as in the case of, I think, some of the folks here that are observing the debate right now on the floor and watching from elsewhere, might work in an industry that has moved Colorado into a position where their thoughts, their work, their experience has made us the producer of some of the cleanest oil and gas pulled from the earth anywhere on the planet. And it's an echo of exactly what the former mine manager who worked down in Australia, who now represents the good people of Alamosa in the southwest corner of the state, the experience he brought. So I want to say thank you to my good colleague for applying your experience to bringing better policy. And I want to say thank you to the people observing this debate for bringing your experience into delivering the cleanest that you can deliver for your industry, oil and gas, to the people of Colorado and beyond the borders of this. I urge your support of Amendment L010.
Senator Pelton B.
Thank you, Mr. Chair.
I urge the support of L010 as well. And here's why. The good senator from Alamosa is an engineer. He knows what he's talking about. He's been there. And when I sat in the Ozone Committee this summer and heard the Colorado Department of Health and Environment say that we produce the cleanest energy in the nation right here in Colorado, that they can do the same thing to make sure with the air quality permits that these pyrolysis technology can do the same thing, because they'll have to go through an air permit. I appreciate the good senator from Alamosa bringing this amendment, and I want to say thank you for that, and I ask for an aye vote for L010.
Seeing no further discussion, the motion is the adoption of L010. All those in favor say aye. Opposed, no. The noes have it. L010 is lost. Senator Priola. There is an amendment at the desk. Will the clerk please read L012?
L012, amend the Transportation and Energy Committee report dated February 28, 2024, page 2, line 7, strike or. Page 2, strike line 20 and substitute or explosive materials or, parens 8, pyrolysis units used to convert municipal solid waste or solid waste derived materials into useful products such as energy, fuels, and chemical commodities, except that this exception does not apply to the 8-hour Ozone Denver Metro North Front Range
Senator
non-attainment.
Priola.
Thank you, Mr. Chair. Members, I move L0112 to Senate Bill 150.
To the amendment, Senator Priola.
Thank you, Mr. Chair. Members, this amendment is fairly straightforward. What it does is the amendment that was adopted, much to the chagrin of the sponsor, what this amendment does is it says pyrolysis can take place, but it has to take place outside of the metro area, North Front Range non-attainment area, because the voters that we talk to in this part of the state are really tired of dealing with air pollution issues. We're already out of compliance with the EPA, and we don't want to do anything to make it worse. So if the folks who support that amendment want this kind of quote-unquote technology to come to their part of the state, this amendment allows that to happen. So I ask for an aye vote on L012.
Seeing discussion, Mr. Minority Leader.
Thank you very much, Mr. Chair. I rise in opposition to Amendment L012. And I'm gonna have to work my way through exactly why I am in opposition to L012.
Senator Priola.
Oh, thank you, Mr. Chair. But the good senator from Monument, I think a pyrolysis factory in Monument or Douglas County would be an excellent idea, based on your prior debate on the prior amendment that was adopted.
Well,
Mr. Minority Leader.
Thank you very much, Mr. Chair. In Monument, we will consider anything for an appropriate amount of time, given the right circumstances. So let's take a look into this. We've got Amendment L012 to Senate Bill 150. What this seeks to do is it's going to, on the second page, strike lines 20 and substitute a bunch of interesting comments. Let's put it in the context of the bill here. We've got I'm having a little bit of tech problem here. It is not working. There we go. I'm on page 2, line 20, the existing language, and this is second read amendment to the introduced bill. On page 2, line 20, we're picking up prohibitions on facilities that incinerate municipal solid waste, and it's basically the definition section. As used in this section, unless the context otherwise require, and it identifies things in detail. A is biochar, means the solid carbon-rich product made when biomass undergoes pyrolysis. How do I say this word? Pyrolysis. Pyrolysis in an oxygen-depleted atmosphere. So you put it in a vacuum, and then you burn it. It makes noises, not unlike brass things falling on the floor, but not the same always. It also deals with hard-to-recycle plastics, which means plastic materials or products that cannot be easily sorted by materials recovery facilities or processed by traditional mechanical recycling technologies, or a lack of end market demand, meaning you're making something that nobody wants. It also intersects with hazardous waste that has the meaning set forth in section 2515-101. But what this amendment would do is it's striking lines 20 and substituting in some additional language here. It wants to substitute in or explosive materials, or, and then it adds a sub 7, pyrolysis units used to convert municipal solid waste or solid waste derived materials into useful products such as energy, fuels, and chemical commodities, except that this exception, talk about a double negative, except that this exception does not apply to the 8-hour ozone Denver Metro North Front Range non-attainment area. So we're going to move it south, apparently, down to the front range ridge of the Monument Palmer Lake Divide, because I guess that if we raise it up into the atmosphere slightly, instead of having a mile jump on the pursuit of elevation, you've actually got not 5,280 feet, but my particular front yard is at 7,400 feet and a few. I always say if it is raining or snowing, blowing or doing something untoward in Colorado, it is doing it in my front yard. So I'm anticipating that when I get home, hopefully here in a few hours, I will be driving home into snow, rain, and hopefully safe but somewhat slippery roads as maintained by the good folks of CDOT in Colorado. I urge your opposition to Amendment L012.
Senator Cutter.
Thank you, Mr. Chair. I would rise in support of Amendment L012. It keeps intact the amendment that was just put on to exempt pyrolysis from, or to preserve the ability to do pyrolysis. All it is saying is that if that's going to happen, it should happen in non-attainment areas. I mean, not happen in non-attainment areas. We have a horrible problem. Marginalized communities are getting the brunt of the pollution and the bad things caused with the burning of this stuff. And so we're just asking that we don't add to the burden of these communities by putting up additional plants that are going to burn plastics or anything.
Senator Priola.
Yeah, thank you, Mr. Chair. And just further underscore, like, this could be a real opportunity for folks in Alamosa. They might put one of these incineration plants in Alamosa because it's outside of the non-attainment area where my constituents and many of our constituents are struggling to breathe. We're out of compliance with the EPA. They might even name the incineration plant after a good senator from that area in Alamosa. So ask for a aye vote on L012.
Division has been requested. You said. It's going to be the one the furthest away from security. Hate this place. God, I got to put it in Coleman. Dang it, Department of Coleman again. That's me, y'all. Hate that guy. Robert,
Majority Leader.
Rodriguez is my idol.
Are we good?
Robert Rodriguez is the
not?
greatest. There we go. Good to go? He's in the back. A division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of Amendment L012 to Senate Bill 150. All those in favor, please stand. Please be seated. All those opposed, please stand. The chair is not in doubt. The motion for the adoption of L012 is lost. To the bill, seeing no further discussion, the motion is the passage of Senate Bill 150. All those in favor say aye. Aye. Opposed, no. The ayes have it. Senate Bill 150 is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise, report, progress, and beg leave to sit again.
The motion for the committee is to rise, report progress, and beg leave to sit again. All those in favor say aye. Aye. Opposed, no. The ayes have it. The committee will rise and report progress and beg leave to sit again.
The Senate will come to order. Senator Coleman.
Thank you, Mr. President. The committee has met and had a number of bills in consideration. Would the clerk please read the report?
March 13, 2024, Mr. President, your committee of the whole begs leave to report it has had under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. Senate Bill 3 is amended, and Senate Bill 150 is amended, passed on second reading, and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Coleman.
Thank you, Mr. President. I move the report.
Motion is the adoption of the committee of the whole report. Where are we?
We're not moving the report. Are we not moving the report?
Did he lay the bills over to Peter?
Yeah. She has an amendment, so we have to. We were.
I thought that all we were going to do, beg report leave to sit again. He was going to make an announcement that they can leave for third reading. But you're saying you want to stay. You have a calendar.
So we can do the. Yes, at the end. So I can rescind that motion.
Let's make sure we're doing this right, because I don't want to lose the last 5
Because he hasn't technically moved.
Can I have that? That's fine.
All good here? Can I rescind my motion? Your motion to move the report.
Did you make the motion to beg leave to sit again?
Yeah. He did.
Yes. So, did you read the report? So we read the report, but we don't vote on it. So there's no amendments right now?
Correct. Correct.
Look at you, you're like, yeah, of course, that's what I was planning on doing. So we're good.
Okay. Now the city will come up.
Now we re-resolve.
Or we can just pass these bills and
So I can leave.
And you can amend.
I'm gonna make that motion now. I'm gonna make that motion now.
Mr. Majority Leader.
Thank you, Mr. President. Pursuant to Senate Rule 21C, I move the Senate grant leave to the Joint Budget Committee to meet while the Senate is in session.
You have heard the motion, and to clarify, the motion was to grant leave pursuant to Senate Rule 21C to the members of the Joint Budget Committee so that they can meet while the Senate is in session. You have heard the motion. All those in favor say aye.
I'm just curious. Because I was gonna make it. No, I get it, I understand, but is it a debatable motion?
Depends if you plan on debating.
Let's move ahead, and I'll come back to it later.
All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the motion is adopted. The Joint Budget Committee members have been granted leave. Have fun. Members, just so it is clear, granting leave to the Joint Budget Committee members means that they can leave, do their work. They also can return for divisions and for motions and for votes if they come up while they are gone. So they are not being excused from the role. They're simply being granted leave from the committee, from the Senate, and may return. Senator Coleman.
I have to call us back in, don't I?
This is re-resolve. I re-resolved it. Senator Chair. Thank you, Mr. President. I move we re-resolve into the Committee of the Whole for consideration of general orders, second reading of bills.
You have heard the motion. All those in favor say aye. Opposed, no. The ayes have it, and the Senate will re-resolve into the Committee of the Whole for the consideration of the general orders, second reading of bills, and Senator Coleman will take the chair.
We're going to do 150 again. No, just kidding. Do over. Hold on a second. What's that? You did something. Something was just dropped on my desk.
Committee will come to order, and the code rule is relaxed again. Would the clerk please read the title to Senate Bill 001?
Senate Bill 001 by Senator Michaelson Janay and Representative Brown concerning continuation of the Youth Mental Health Services Program and in connection therewith requiring an annual evaluation of the program.
Senator Michaelson Janay.
Thank you, Mr. Chair. I move Senate Bill 001 and the Health and Human Services and Appropriations Committee reports.
To the Health and Human Services Committee reports, Senator Michaelson Janay.
In the Health and Human Services Committee reports, we made some changes to the program so that the program could continue on with the Behavioral Health Administration and cleared that language up.
The motion is the adoption of the Health and Human Services Committee report. All in favor say aye.
Aye.
Opposed, no. The ayes have it, and the Health and Human Services Committee report is adopted. To the Appropriations Committee report, Senator Michelson Janae.
In the Appropriations Committee, we cut the amount from 11 million to 6 million, which is actually what's needed to run the program.
Senator, for discussion, the motion is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. The Appropriations Committee report is adopted. To the bill, Senator Cutter.
Thank you, Mr. Chair. The iMatter program provides youth up to age 18 and 21 for youth and special education programs, up to 6 free therapy sessions with a licensed clinician. The state program will end in June 2024 when it is expected to run out of money. So this will extend and improve the iMatter program. This has been a wildly successful program that my colleague here from Commerce City originally ran, and I'm so pleased to be running this with her again this year. 13,273 youth have received free therapy sessions. 50,000, in fact, more than 50,000 sessions were conducted since it began in 2021, and 62 out of 64 Colorado counties were represented amongst the youth. So this is a successful program, worth continuing. It makes a difference, and we hope you can support that today.
Any further discussion? Senator Michelson Janae.
Thank you, Mr. Chair. Thank you so much for joining me on this bill, Senator Cutter. I just wanted to add that you might remember this was a COVID-era program, and we were trying to figure out how do we solve the problem of kids with toxic stress returning to school without therapy. So we wanted to make therapy available for all of our kids and remove the barriers to entry. We did that. We removed barriers to entry, and the program has been, as you heard, very successful, and we hope to continue on with this program in its successful manner. I urge an aye vote.
Any further discussion? Senator Van Winkle.
Thank you, Mr. Chair, and I thank the sponsors of Senate Bill 1 for bringing it forward. Just a bit of background knowledge here. And what the bill does is it continues the temporary youth mental health services program. I guess are we keeping temporary? No. We're removing it from temporary. That is correct. And it's commonly known to most people, and this is something that's very common in schools. When you talk to any teacher, they have high praise for it, and it's known as the iMatter program, which is it's scheduled to be repealed on June 30th this year. It also changes existing law by requiring the Department of Human Services to report to the General Assembly once each year instead of twice annually. Now, a little background here. This builds upon the work of two previous bills, the first one being House Bill 21-1258, which was a rapid mental health response for Colorado youth, sponsored by my colleague from Commerce City and myself, as well as Senator from Denver, I believe. Aurora. Yes. Thank you, Mr. Chair. My apologies. And what this bill was is we were coming out of the COVID crisis. We were seeing our teenagers and our youth in Colorado in serious distress. They were taken out of their school environments. They were taken out of sports. They were taken out of really their daily life. And they were facing, in our Colorado youth at the time, and still to some extent today, faced an unprecedented wave of mental health problems and crises. And so we stepped forward with this bill in 2021 and passed it. It was followed the very next year by school security and school behavioral health services. And that bill was actually sponsored by 2 representatives and now 2 senators. All 4 senators are now here in this chamber today looking at this piece of legislation. And both those bills, they passed unanimously in the Senate. Both bills have had praise from the public. Now, the iMatter program, what it does, it provides talk therapy through 6 free government-funded visits. That's an increase on the original legislation. It doesn't deal necessarily with direct, very intensive crises or perhaps if you're beyond a breaking point as a young person in Colorado. They try to divert you to crisis hotlines such as 988. and others. Now, there are some issues with this bill before us today. And for anyone paying attention at home, it's the 988. It's something that's relatively new. I wish we probably need a greater advertising campaign behind 988. It's like 911, but 988 for mental health services. And of course, Colorado also has a suicide hotline for crisis intervention. But what this program is to be able to get any youth age student mental health checkups, mental health visits, really simply using their phone or iPad or a computer. Now, there are some problems that I have with the bill that is before us today, and that is one of the original intents behind the bill in 2021 and 2022 was to ensure parental consent, parental knowledge, parental involvement, because we're oftentimes dealing with here, well, in all cases, we're dealing with here children, minors, school-aged children. And I have heard instances where, although insurance information is requested, that there are loopholes in that system that invalid information can still be submitted, and the parents may not necessarily be notified that their very own child living under their roof may be going through a mental health crisis, something that I, as a parent, I know would want to be informed about and want to be very proactive in helping with. And then secondly, the only other issue is when we passed the bill in 2021, it was brand new. 2022, there were needed improvements that were included in that piece of legislation, and now here we are in 2024. And one of the things the bill does is it removes it from the temporary program, which is fine, but it effectively repeals any sunset or any check on the program whatsoever and continues it indefinitely. I do have issue with that because it still is a program that is in its very early stages. It's not a program I want to see go away by any means, but I do think there needs to be a check on it through the legislature, and by simply providing a report to the legislature every 2 years, I just don't think that's as nearly as good as a sunset report that thus leads to a bill that legislators are able to look at, analyze, get public testimony on, and pass it into law. So those are my thoughts on the bill. I thank the sponsors, and I know iMatter has done a great amount of good for our school-age youth and families of Colorado, but the bill itself has a few particular things I would like to see change. So thank you.
Senator Pelton B.
Thank you, Mr. Chair. I have to tell you that iMatter has done a great deal for my district. We had, during COVID, I'm going to get a little emotional, so I'm sorry. During COVID, we had 12 youth suicides in a 10-county region. So we don't have the resources in rural Colorado that other counties counties do out in where I live. And one of those young ladies was a friend of mine. Well, I knew her on several times. I knew her family, and my brother-in-law is the superintendent now, but he was the principal of a school. And that young lady took her life because there was really hard to get resources where we live. This helps. This has helped quite a bit. And I want to say thank you to the good senator from Commerce City, because this is a big deal. My only problem with the bill today is that we're doing it before the long bill. And I agree that this is a really good program and it needs to keep going, but we really need to pay for schools first. We really need to do the budget first, and then we can get this out. And I appreciate all the work that this program has done and how it's helped my community. I just think we need to do the long bill first. We need to pay for the schools first, and then we can look at this, and this can be the next thing that we pay for. But it needs to happen now. And I appreciate everything that the good senator from Commerce City has brought to us with this bill, and the good senator from Jefferson County. But I just think that we need to put priorities. And I understand that our youth needs this, and they're doing a great job with offering the service in our schools. But I just really want to see everything paid for, and then we can do this bill. So with that, I move to lay over this bill until April 8th, Mr. Chair.
April 8th?
Yes.
Is there any further discussion? Senator Michelson Janae?
Thank you, and thank you so much for my colleague from Peltonia. Clearly, if your brother-in-law is the principal, it's serious Peltonia business now. But I would kindly ask for a no vote on this motion today.
The motion is to lay over Senate Bill 001 to April 8th. All those in favor say aye. Aye. Opposed, no. No. The noes have it, and this bill will continue on the calendar as planned. Any further discussion? Senator Gardner.
Thank you. I keep eyeing that tag on the front of my desk. It may not yet be bobbing time, but it's coming soon. Mr. Chair, colleagues, I think this bill is a great program. I support this program. I participated in the legislation to make this program come into being. I, once again, strongly support this program. I urge a no vote on this bill at this time. Put all that together. Here's the problem. There's a $6 million fiscal note before we've done the long bill. My colleague from Sterling, North Peltonia, moved to lay over the bill till April 8th, which was incredibly responsible. Because we just have not resolved all of the questions of whether that $6 million is there. Not because this isn't a great program, not because I don't want to continue it and urge all of you to continue it, but there's an order in which things need to be done here. It is a shame, by the way, that permission has been granted to our members of the Joint Budget Committee to go and do what is vital work to get the long bill together so that we can introduce it and see if we've got this $6 million to do this bill. It's also a shame because the senator from Brighton, from Weld County, is not here to make the passionate speech that she did in appropriations last week about why this bill's passage is premature. We now reach the point in our session where we send the JBC over to do their work, and then we pass bills, assuming they're going to be able to find some money that hasn't been found yet. I regret this very much because I support this program and I support what it does. But if we don't know, and by the way, the statement was made in general, and I'm paraphrasing somewhat, but the statement was made and the indication was made in appropriations that, oh, it's got to go to the House and House appropriations, they'll take care of it. Who in the world lets the House take care of things for them? I don't have a lot of confidence in that. If you do, come and talk to me. I'll give you some reasons why not. And I have a lot of respect for the House. I served there for longer than I've served here, for a while anyway. But let's get things in the right order. We should have laid this over, but we're not, and for that reason, I'll be a no on second reading. Thank you.
Any further discussion? Senator Van Winkle.
Thank you, Mr. Chair. And just to kind of put a point on that, it is $11 million that will be essentially appropriated forever until the program gets reviewed. I do wish there was a sunset review. I think the very biggest thing for me, however, in the bill is just strict closing those loopholes around parental knowledge, parental consent, and parental notification. If parents aren't involved, or if parents aren't required to at some point be involved with their students' mental health, it could grow into creating a very good, a very popular program into something that, at least among parents, that a parent might think that the program or something nefarious is happening. Just when a parent doesn't know what's happening with their kids, we tend to think the worst case scenario, and I don't want that to happen with the iMatter program or the licensed therapists that are signed up to help with it. So if the folks who run the iMatter program are watching, parental notification, parental consent, very important to me as a legislator. Thank you.
Any further discussion? Seeing none, the motion is the adoption of Senate Bill 001. All those in favor say aye. Aye. Opposed, no. The ayes have it, and Senate Bill 1 is adopted. Will clerk, Mr. Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 14 to the end of the calendar.
The motion is to lay over Senate Bill 14 and the calendar. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Senate Bill 14 will lay over to the end of the calendar. Mr. Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 19 to the end of the calendar.
The motion is to lay over Senate Bill 19 to the end of the calendar. All those in favor say aye. Opposed, no. The ayes have it. Senate Bill 19 will be laid over to the end of the calendar. Will the clerk please read the title of Senate Bill 20?
Senate Bill 20 by Senator Roberts and Representatives Lindstedt and Pugliese concerning authorization for certain persons licensed to sell alcohol beverages at retail to sell alcohol beverages for consumption off the licensed premises.
Senator Roberts.
Thank you, Mr. Chair. I move Senate Bill 20 and the Appropriations Committee report.
No Appropriations Committee report, just the amendment, correct?
We're to the bill?
To the bill.
All right. Yes, thank you, Mr. Chair. There's an amendment at the desk.
There is an amendment at the desk. Would the clerk please read L002?
L002, amend printed bill,
Senator
page 2,
Roberts.
line 2.
Thank you, Mr. Chair. I move L002.
To the amendment. Senator Roberts.
Thank you, Mr. Chair. This amendment clarifies that the restaurants or establishments that are selling the alcohol as part of their to-go program need to only make that alcohol available by the assistance of an employee of the licensee. I would ask for an aye vote.
Seeing no further discussion, the motion, Senator Gardner, discussion on L002. Okay, seeing no further discussion, the motion is the adoption of L002. All in favor say aye.
Aye.
Opposed, no. The ayes have it. L002 is adopted. To the bill, Senator Roberts.
Thank you, Mr. Chair. Colleagues, Senate Bill 20 extends and makes permanent in Colorado law a program that has existed in our state since COVID that has proven to be very popular by Coloradans, but very important to our small businesses and the restaurants in every single one of our communities. What originally started as a way to ensure restaurants could stay open during periods of lockdowns and restrictions has turned into a custom and practice for restaurants and customers alike. This bill takes away the repeal date after we extended this a few times legislatively, and it's a crucial source of revenue for our restaurants across the state that they've come to rely on. And given that it has worked well, I think this bill is appropriate to extend it and allow this privilege and source of revenue to continue in perpetuity in Colorado. I'd ask for an aye vote.
Senator Gardner.
Thank you, Mr. Chair. Well, this bill continues what is a very good program. I'll tell you why it's a very good program. If you think about it, you could have your aide, assuming they're of the appropriate age, run out and get you a drink this afternoon. And I don't know about you, but I could use it. I ask for an aye vote.
Senator Sullivan.
Thank you, Mr. Chair, and thank you for bringing this bill forward. I heard this bill in committee, and one of the people that came to talk to us and to ask for my support on this bill was a man by the name of Mojo Monjack. So, Mr. Monjack, I just wanted to let you know that I am supportive of the industry that you're in and what you're doing, and for that reason, I'll be voting yes on this bill.
Senator Van Winkle.
Thank you, Mr. Chairman. And for the listening audience at home who heard me just rally against a program that is indefinite, I do want to point out that this is not necessarily a program. What it is a freedom allowed to the people of Colorado, not necessarily a program that continues on and on. In the last case, it was $15 million that had been spent, and there's $11 million going on. This is simply a freedom allowed to the people of Colorado, and freedoms should be continued indefinitely, unlike government programs.
Mr. Minority Leader.
Thank you very much, Mr. Chair. I don't know whether the bill sponsor would be amenable to this, and I don't know whether the chair would allow it, but I'd offer a conceptual amendment to name this section of statute the Mojo Monjack section of statute, Mr. Chair.
Yeah, man, I think that's, Mr. Minority Leader, that's a horrible idea, but thank you for at least offering it.
I withdraw the suggestion.
Thank you so much for
motion.
withdrawing that. Senator Roberts.
Thank you, Mr. Chair. It was some very good testimony from Mr. Monjack, if you want to go back and listen to the to the Business Committee. I just wanted to put one point on the record in regards to the amendment that I offered. We moved a little quickly there. This says that alcohol can be displayed, but it needs to be sold with the assistance of an employee. Nothing about this amendment is intended to prohibit a restaurant from displaying wine bottles or other bottles as decor. So I just wanted to make that very clear. That is not being prohibited by this amendment. This is about the alcohol that's actually being sold. I was speaking on the amendment. We're on the bill. I'm just putting that into the record for clarity and for anybody who might listen to this later. Thank you.
To the bill, Senator Hansen.
All right. Thank you very much, Mr. Chair. And members, I just wanted to quickly share a few of the bits of the conversation that came out in the Appropriates Committee on this bill that I think are important for our consideration of the full piece of legislation. Senate Bill 20 is focused, of course, on to-go alcohol from restaurants. I have absolutely no problem with that. We have voted on that several times. And let's just set up the framework and make that a permanent part of our statute here. Totally fine. My objection, though, is really around how the fiscal note is structured. And I've had great conversations with the sponsor. I've had great conversations with the Department of Revenue on this. But if you look closely at the fiscal note, and I know all of you do that each morning before we start floor debate, the fiscal note has one kind of glaring issue that I think we need to grapple with here and in other places, which is it creates a situation of one program cross-subsidizing another. And this is meant to be a fee that goes into a cash fund that pays for itself. That's how we typically do these things across the state budget. And unfortunately, in this case, we have a fee that is proposed to implement Senate Bill 20 that it's $11 per licensee. Okay, so far so good. That produces about $23,000 in total amount of revenue into that cash fund. But the DOR says it's going to cost us $86,000 to implement this program. So 4x is the gap. And that's something I think, we might be able to ignore or look the other way on something that is $50,000. Okay. But I think it's something we have to look at really closely across every part of the budget. Because essentially what's going to happen here is LED is going to use money from other licensees, sometimes the same restaurant, sometimes not, to cross-subsidize, to pay for implementing Senate Bill 20. And again, I don't have any problem with the policy, but we really have to get this right when we think about program design. The fee structure needs to line up to the costs that we're planning to implement. That feels like a good principle for us to stand on. And unfortunately, Senate Bill 20 doesn't do that. Now, if we decide to move this forward today, that's fine. Again, I'm fine with the policy. But we will be using some restaurants' extra fees to pay for implementing to-go alcohol. And that seems like a bad practice for us to start. And I want to make sure that we don't continue it in the future. And my promise to you is I'll remain vigilant on this issue in Senate Appropriations.
Seeing no further discussion, the motion is the adoption of Senate Bill 20. All those in favor say aye. Opposed, no. The ayes have it. Senate Bill 20 is adopted. Will the clerk please read the title of Senate Bill 65?
Senate Bill 65 by Senators Hansen and Fields and Representatives Froelich and Ortiz concerning the use of mobile electronic devices when driving a motor vehicle.
Senator Hansen.
Thank you, Mr. Chair. I move Senate Bill 65 on second reading.
And the Transportation, Energy, and Appropriation Committee report?
Yes, thank you. And the T&E report and the appropriations report. That's
to
correct.
the T&E report, Senator Hansen.
Thank you very much. Made a few minor adjustments to the bill in T&E, technical adjustments to help with implementation, and I urge adoption of the report.
Motion is the adoption of the T&E committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and the T&E committee report is adopted. To the Appropriation Committee report, Senator Hansen.
Thank you, Mr. Chair. Members, very small appropriation on this bill to implement some of the programming changes that come along with the different provisions of the bill. Urge adoption of the appropriations report.
Motion is the adoption of the Appropriation Committee report. All those in favor say aye. Any ayes?
Aye.
Opposed, no. The ayes have it, and the Appropriation Committee report is adopted. To the bill, Senator Fields.
Thank you, Mr. Chair. Members, it's an honor to bring to you Senate Bill 65. This bill is about saving lives because we know that if you have an electronic device and you're trying to text and drive, that's a distraction. And we want you to stay focused on the road. We know that we all share the same roads. We share the roads in our streets with school buses, with kids who are in the neighborhood who may not be watching. And when you try to text and drive, you think that you might be multitasking. You could just look away for 3 seconds and you could impact someone's life forever. My senator and my co-prime sponsor and I, we presented this bill and we heard some very compelling, passionate stories. People lost their legs. Some people died because someone, even though it's illegal to text and drive, they wanted to be so much focused on responding to that text, and they end up in a situation where they hurt someone because they were distracted. We want all hands on the wheel. We want all hands on the road because we all use the same road. Have you seen how many people are on their phones texting and driving? And a lot of times when you try to do that, you're weaving. The research will tell you that when you are texting and driving, you start to go across the line and you start to weave just as if you were intoxicated. This message, and I'm quite sure my co-prime sponsor from Denver are going to tell you this is about changing the mindset and the culture as it relates to distracted driving when it deals with an electronic device. It's time's up. Over the course of the years and maybe decades, we are now accustomed to putting on a seatbelt. There is nothing wrong with implementing traffic rules that keep us all safe. That's what this bill does. We're trying to shift the culture to safety, like what we did with traffic, with seatbelts. We had one of our witnesses bring in a $12 or $13 device that you can get on Amazon, maybe you can get them at other local stores, that you can just put it on your dashboard, you can put it whatever. You don't need to pick up the phone and do one of these numbers or texting while you're driving at the expense of someone else's life. And it could be your own. And it doesn't take much time for you to look away, 3 seconds, and you can harm somebody really, really seriously. And our kids are watching. So if you're an adult and you're texting and driving and you have young drivers, or maybe they're about to be drivers, you are modeling the kind of behavior we want them to demonstrate when they have the authority and the license to be behind the wheel. We need to change the mindset in making sure that everyone's focused on their own personal safety, not just for them, but for those who might be walking across the street. So members, that's what this bill is all about. It's about saving lives and shifting the focus to safety for the good of our community and for the good of Colorado roads.
Senator Hansen.
Thank you very much, Mr. Chair, and such a pleasure to bring this bill back to you with the good senator from Aurora. This is a deeply personal bill for me because I've been hit twice by drivers on their cell phones. And in both cases, they had the phone up to their ear, were not focused on the road, and hit me as I commuted to work on my bike. Both times. And luckily, I'm here to tell you about it. Other folks aren't so lucky. I got bruised, I got scraped, had some red marks on my face, but I'm here to tell you about it because I got lucky. And that's not always the case in this situation. This is also deeply personal for me as a dad of 2 teenage boys who have their permit and their license. Because the good senator from Aurora is exactly right. We need to model better behavior. Next time you're at a stoplight, driving home this evening to beat the snowstorm, look left, look right quickly at the red light that you're stopped at. Pretty good chance the person next to you is on their phone, texting, talking, calling. That's the focus of this bill. We need to change the way that we are interacting with our devices in our cars. The data is clear. The last thought I want to share with you is to reinforce the approach that we're taking in this bill, that it's not about punishment. This is about changing behavior of how we're using the phone. All the fines, the ticket, this is a traffic ticket, is waived if you show you have a Bluetooth device. That's all you got to do. Waive the fine, waive the ticket. You just got to show that you're ready to make that change to using a hands-free device. That's what we're asking to happen here. And it's exactly how we approached the behavior change when it came to seatbelts. So this is not a bill about being punitive in any way. And getting a Bluetooth device is super easy. And every car made in the last 5 or 6 years has one anyway. And they're $10 if you need to get a new one. Easy change, easy way for us to improve the safety in our state. I urge your support of Senate Bill 65.
Senator Marchman.
Thank you, Mr. Chair, and thank you to the bill sponsors for bringing SB 65. This is a bill that's really exciting to see that we're getting to hear it on the floor, because I had 67 of my cutest constituents, they're 4th graders, and they came to the Capitol after hosting me in their classroom to ask me, what are you doing to fix distracted driving in Colorado? And it was so fun to get to see their projects. We were up in room 352, spent an hour with them. But they brought this idea. And so I just want to share how important it is that we do involve our kiddos. So this hands-free requirement is so significant to ensure the safety of drivers and pedestrians and bicyclists as well. This measure has been championed by our youth, and it addresses the growing concern over distracted driving and sets a new standard for responsible mobile device use on the road. Specifically, one of the things, so the kids came with projects and they wanted to share 4 of their ideas. One of the ideas was one that is implemented in this, and it's the hands-free device. And they showed it to me. They showed me one of these $10 things. And it's important, it's cheap, but it also showcases the importance of actually listening to our youth and incorporating their ideas for the betterment of our community. So again, I do urge your support of SB 65. I thank the sponsors for bringing it forward, and I thank my very special constituents at High Plains Elementary School for bringing this to our attention. Thank you.
Senator Simpson.
Thank you, Mr. Chair. Just a couple of thoughts. I was in committee when we heard this bill. I've been here 3.5 years and certainly have heard and seen some compelling emotional testimony over that time period in committees. But I just highlight, I know the good senator from Denver and Aurora touched on a couple of these, but to think about people, individuals standing at the back of their vehicle, in a parked vehicle, getting something out of the trunk of the car, and a distracted driver ran into him. And I mean, it was just so compelling. And then even more compelling was somebody who shared with us, a bicyclist who shared with us what I guess is a GoPro, a video of him riding in a bicycle lane where he should be riding and getting struck by a distracted driver. And the driver wasn't speeding 55 or 60 miles an hour. It was relatively slow speed, 30 miles an hour, 40. But it was just compelling to watch what happened to that gentleman on a bicycle. And he was willing to share that with us in committee and then also come to the committee and testify, again, very emotionally. So I supported the bill, think it's good policy, and just wanted to highlight again how emotional and compelling that testimony was today in the Transportation Committee. So thank you to the sponsors for bringing it, and I'll continue to support Senate Bill 65.
Seeing no further discussion, the motion is the adoption of Senate Bill 65. All those in favor say aye. Aye. Opposed, no. The ayes have it, and Senate Bill 65 is adopted. Will the clerk please read the title to Senate Bill 14?
Senate Bill 14 by Senator Hansen and Representative McLaughlin concerning authorization for granting a high school diploma endorsement related to climate literacy.
Senator Hansen.
Thank you, Mr. Chair. I move Senate Bill 14 on second reading.
And the Education Committee report and appropriations?
Thank you for that reminder and both of the committee reports.
To the Education Committee report, Senator Hansen.
Thank you, Mr. Chair. Members, very small changes made in the committee, basically just making sure we can implement it smoothly with the Department of Education and urge adoption of the committee report.
Motion is the adoption of the Education Committee report. All those in favor say aye. Opposed, no. The ayes have it. Education Committee report is adopted. To the Appropriations Committee report, Senator Hansen.
Thank you, Mr. Chair. Members, very small appropriation on this, just a little bit of support from the State Department of Education to keep track of the number of students that will be utilizing this over the coming years, and ask for your adoption of the Appropriations Committee report.
Motion is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Appropriations Committee report is adopted. To the bill, Senator Hansen.
Thank you, Mr. Chair. Fellow members, Senate Bill 14 is focused on using a tried and true method that we have evaluated here before, things like the civics seal, the bilingual seal, that high school students can get onto their official transcript to signal to the rest of their world that they have taken the time and the effort to upgrade a certain set of skills. And that's exactly what we're doing with Senate Bill 14. And we're expanding that to an area that has a huge amount of interest in the state of Colorado, and that's working on conservation and climate change. We got direct ask for this bill from different high schools around the state that are already doing these types of programs and want a way for their students to be able to show that clearly on their transcript. Very straightforward bill, very little cost here at the state or at the local level. In most cases, these are continuation of ongoing programs that already exist, but now the students will be able to get this seal on their transcript and prove to the rest of the world some of the skills that they were able to develop during their time in high school. I urge a yes vote on Senate Bill 14.
Mr. Minority Leader.
Thank you very much, Mr. Chair. I rise in opposition, boy, but it's about the most tepid opposition you'll get out of me this session on a bill. This is an example of where we in public education, K-12 education specifically, are majoring on the minors. We've got a big challenge. We've got a real crisis in public education. I'm grateful to have been the author of the amendment to the School Finance Act last year with support from my caucus over the years preceding that to fully fund public education at the Amendment 23 required levels. And even with that progression of constantly improving funding, reading based on a dearth of leadership, based on any number of lack of anti-competitive features that are baked into the government-run, union-dominated K-12 school system that we have today. We're failing 50% of the students. And that is to the point of my argument. That is where we need to be focused. Reading, writing, arithmetic, basic academic attainment must be what we are focused on. This is a nice, shiny object. It's something that's meaningful to some people. But I believe this sort of thing, and this is the least offensive, in my opinion, of the many different sorts of things we do in public education to distract away from what we should be focused on. But this is, even a small distraction, a distraction that takes us off focus on reading, writing, and math and science attainment. We should be focused like a laser on that, because we can't, quite frankly, friends, allow our system to continue to fail 50% of the students. And don't ever lose sight of the fact that when I say fail 50% of the students, we're failing a larger percentage of black and brown children and children from economic challenge in that metric as well. Thank you, Mr. Chair. I urge again a no vote, kind of, sort of.
Thank you. Senator Marchman.
Thank you, Mr. Chair. And I rise in support of SB 14. Oftentimes, when students are struggling in writing, reading, or math, science is what brings them together. This science is actually a really great way for kids to bring all of their learning together. I used to teach gifted and talented. If kids were identified as gifted in reading or writing, I often would pair their goals with a science goal because it's their priority. It's what they care about. The other thing I'll say is the students in my school are in an existential crisis about climate, and absolutely they are asking for support and just to get this climate on their credentials, or on their diplomas. So I appreciate you bringing this bill, and I would urge your support on SB 14. Thank you.
Thank you. Senator Gardner.
Thank you, Mr. Chair. Well, the question is not whether science brings students together and motivates them toward literacy, or whether or not we should be teaching about climate. It is more what the minority leader has noted, that it's one more shiny thing out there to distract us. I unfortunately, or you may say fortunately, am not going to be here next year. So I'll be unable to carry a bill for a designation on the diploma of an endorsement called the literacy endorsement. I urge a no vote.
Thank you. Any further discussion? Yes, Senator Pelton B.
Thank you, Mr. Chair. So when I saw this bill, I was like, wow, this is what we're concerned about. We're not concerned about our kids doing math and English, but we're concerned about this. It's been pretty rough to sit and help my family, my kids. They're pretty smart. They take after their mother, thank God. But I just worry about, let's focus on getting our kids proficient at the other things before we worry about this. So I also urge a no vote.
Thank you. Senator Fields.
Thank you, Mr. Chair. This is to the young people of Colorado. I speak to them and I'm engaged with them. I see them every day. And young people are concerned about our environment. They're concerned about the air we breathe, the water we drink, and the climate and the planet that we plan to leave them with. This is very important to give young people the opportunity to get some credentials and some certification to help them be better stewards of our earth. This is not a no vote. This is a yes vote. Our kids need to learn and know how to recycle. They do it already. You see them with their refillable bottles where they're drinking out instead of using plastic. There's a movement going on as it relates to client science. So this is all about having the literacy to prepare our young people for the environment that they want in the future. Members, please vote yes on Senate Bill 14.
Thank you. Senator Hansen.
Thank you very much, Mr. Chair. And just a brief closing comment. Climate is not a distraction. I really appreciate the remarks from the good senator from Aurora. It's not a distraction. Second, we know that engaged students perform better. I hear the comments loud and clear that we need to continually improve student performance. That's absolutely true. And I actually believe that Senate Bill 14 will contribute to that. Because when students are engaged in learning that they care about, that they love, and they have a chance to earn something like this seal to show the world how much they care and that they've developed skills, that leads to better student performance. They do better in all of their classes. Please support Senate Bill 14.
Thank you. Senator Baisley.
Thank you, Mr. Chairman. So students that are considering the science of climate, I would encourage you to look at, so just Google on YouTube a video called A Brief History of Colorado Through Time, and it was created by University of Colorado a few years ago, and it shows the history of the state of Colorado and some amazing things about it, how it used to be in the southern hemisphere. The ground we're on right now at one point was located in the southern hemisphere. It was also below sea level. So there was at one point an eastern shoreline to the ocean in Colorado. The climate that changes over the many years is a scientific fact, and you can watch this very interesting video called A Brief History of Colorado Through Time, the Geology of Colorado. And this is the kind of science that I think is worth teaching, not the kind of science that says, hey, human civilization is bad for the earth, but rather let's understand what the climate really is all about. Be scientific oriented and not agenda ridden. Thank you, Mr. Chairman.
Thank you. Seeing no further discussion, the motion before us is the adoption of Senate Bill 14. All those in favor say aye. All opposed say no. The ayes have it. Senate Bill 14 is adopted. Would the clerk please read the title to Senate Bill 19?
Senate Bill 19 by Senator Smallwood and Representative Vihil concerning remuneration-exempt identifying placards.
Thank you. Senator Smallwood.
Thank you, Mr. Chair. We move Senate Bill 19 and the appropriations report.
To the appropriations report.
Colleagues, appropriation, you'll notice, is small cash funding. What we're doing is adding an additional placard for remuneration-exempt Coloradans, those that are unable to use parking meters, parking devices, and that sort of thing. So this is cash funded for those folks that want to take advantage of what will soon be a second placard that would be available for them, and we'd ask for your vote.
Thank you. Seeing no further discussion, motion before us is the adoption of the appropriation report to Senate Bill 19. All those in favor say aye.
Do we have to do the report first?
Oh, I'm sorry. I thought you did the report.
Yeah. I did. I moved both.
Okay. Is there any further discussion on the appropriations report? Seeing none, the motion before us is adoption of the appropriations report. All those in favor say aye.
Aye.
All opposed say no. The ayes have it. The appropriation report is adopted. To the bill. Senator Smallwood.
Thank you, Mr. Chair, and thank you, colleagues. Shout out to my co-prime sponsor for helping what seems like an easy bill, but is a little more complicated when you get into the weeds of it. But you're doing a great thing here, helping those folks, and it's only a handful, 400 or 500 Coloradans that take advantage of these remuneration-exempt placards, and we're doing a great thing. Would ask for your aye vote.
Senator Coker. No? Okay. Seeing no further discussion, the motion before us is the adoption of Senate Bill 19. All those in favor say aye.
Aye.
All opposed say no. The ayes have it. Senate Bill 19 is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
The motion before us is to rise and report. Seeing no objection, the committee will rise and report.
Okay.
You want to finish up?
Okay.
Thank you. You want me to do it, or you want to wait for Steve? Because it doesn't. Because I got it. The Senate will come to order. Senator Exum.
Thank you, Mr. President. I move for the adoption of the report. Oh, wait a minute. Do I need to say something before that?
Yes, thank you, Mr. President. The committee has met.
Okay. Mr. President, the committee has met and had a number of bills under consideration. Will the clerk please read the report?
March 13, 2024, Mr. President, your Committee of the Whole begs leave to report it has had under consideration the following attached bills being the second reading thereof, and makes following recommendations thereon. Senate Bill 3 is amended, Senate Bill 150 is amended, Senate Bill 1 is amended, Senate Bill 14 is amended, Senate Bill 19 is amended, Senate Bill 20 is amended, Senate Bill 65 is amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Exum.
Thank you, Mr. President. I move for the adoption of the report.
Is there an amendment? Oh. The motion is the adoption of the committee of the whole report. There is an amendment at the desk. Will the clerk please read S002 to Senate Bill 3?
S002,
Senator Kirkmeyer.
Judiciary.
Senator Kirkmeyer.
Thank you, Mr. President. A little cow amendment here. I move amendment S002 to Senate Bill 3.
To the amendment, Senator Kirkmeyer.
Thank you, Mr. President. Members, during the discussion on this, I had an amendment that would have allowed for that the Bureau, instead of just reasonably communicating with, or what is now I consider not even, just got worse in the bill, that the CBI, Criminal Bureau of Investigation, would, prior to beginning an investigation, the Bureau shall request and obtain consent from local law enforcement agencies and shall collaborate with the district attorney's office. So again, this is very consistent, which is what is already in state statute. Thank you. This is very consistent which is already in state statute that requires the Bureau to have the local law agency to request assistance from them. If you remember, I don't know if you all were here during the discussion, but what is happening with this legislation is
Sorry, Senator Kirkmeyer, 1 second. Members, we are hearing an amendment to the committee of the whole report. Let's make sure we're paying attention. Senator Kirkmeyer.
Thank you, Mr. President. All right, members, during the debate on this one, I had an amendment that said that prior to beginning an investigation, the Bureau shall request and obtain consent from the local law enforcement agency. If you remember, if you were here during debate, you would have heard me talk about what's currently in statute, and what is currently in statute is that the local law enforcement agency, the state agency, the district attorney, anyone involved in law enforcement would have to request the assistance of CBI, and then CBI, the Criminal Bureau of Investigation, would have to receive approval from their director before they could work with and partner with local government law officials. Now, I am not saying that I'm trying to think how to say this. Sorry, we had to run over here. What I'm saying with this is the CBI, instead of just walking into someone else's jurisdiction, like the sheriff or the local law enforcement, the police chiefs, walking into their jurisdiction, that they should have to request and obtain consent from that jurisdiction. We have all sorts of situations in place where there's mutual aid that they could work with the local government agencies on, but there's also what the local government agencies are doing. They need to know who is working in their jurisdiction and who's doing investigations in their jurisdiction. I'm talking about a provision that essentially would provide life safety for those law enforcement agencies that may be in an investigation of their own. And if the Bureau does not understand that that investigation is occurring, they could trip into an investigation, totally mess it up, make it so that we couldn't get those people who are breaking the law, get them under control and get them put into jail. But instead, they could mess up an investigation, and they could also endanger the lives of those law enforcement people that were in already doing an investigation. There's a lot of stuff that happens in an investigation. They don't happen overnight. There is no reason why the Bureau should not, there's no reason why they shouldn't be getting a request and obtaining consent from the local law enforcement agency. In fact, my amendment was very consistent with what is in law now. It's in there in 4 different places, where if the Criminal Bureau of Investigation wants to enter into assistance with the local law enforcement agency or other types of law enforcement agencies, that there has to be a request. There has to be a request from the local law enforcement agency. Then they have to get approval from their director so that everybody knows what's going on. Everybody knows who's working in the jurisdiction and that they are working together. Even in the case of investigating an arson, it is the fire department that has to put in a request to the Bureau to have them come help them. And then they have to inform everybody that the Bureau is now involved as well, so that local law enforcement knows what's going on. So again, this amendment is to basically say that Amendment L008 to 24003 did pass, and I ask for a yes vote. Oh, I'm taking my cow with me up here.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote.
Mr. Minority Leader.
Colleagues, I want to call out the importance of this amendment. This amendment gives the truth or the lie to the bill. If it's about coordinating with law enforcement, if it's about making the public safer, you need to take this amendment. This amendment is what lines it up so that the people who are already investigating have the ability to maintain authority over the investigation, protect the rules of evidence, make sure the chain of evidence remains in place, et cetera, et cetera. If you reject this amendment, you're basically saying we want another statewide police force. It's as clear as that. Accept the amendment, back the badge, back law enforcement, make it sensible, protect the people.
Seeing no further discussion, the motion is the adoption of S002 to Senate Bill 003. Are there any no votes? Senators Hansen, Roberts, Exum, Gonzalez, Janal, Zenzinger, Bridges, you were standing behind Senator Roberts' chair. Are you a no? Ann Mullica, Sullivan, Jaquez Lewis, Michelson Janae, Cutter, Hansen. Wow, Henriksen. Let's just go on the record that I don't think that all white men look the same. Marchman, Danielson, Colker, Winter, Fields, Priola, Buckner, Finberg, Rodriguez, I said Finberg. I hope so. I think so. Rodriguez. Please add the president. With a vote of 12 ayes, 23 noes, 0 absent, and 0 excused, S002 to Senate Bill 3 is lost. Would the clerk please read S003 to Senate Bill 3?
S003, amend the
Senator Van
Judiciary
Winkle.
Committee report.
Thank you, Mr. President. I move S003.
To the amendment, Senator Van Winkle.
Thank you, Mr. President. We had great debate about this on second reading today. It's the kind of the big amendment that we discussed first. It took a large chunk of the time on the bill. It's the one that has 3 parts to it. It limits the investigations to individuals who received a denial from of their firearm check from the NICS system or a CBI check. Second part, it requires probable cause, which really is the basis, should be the basis of any criminal investigation. And then finally, it says, prior to an investigation, the Bureau shall obtain approval from the local law enforcement who has the rightful authority. I ask for a yes vote.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote.
Seeing no further discussion, the motion is the adoption of Senate Bill of S003 to Senate Bill 3. Are there any no votes? Senators Exum, Mullica, Hansen, Gonzalez, Janal, Mr. Majority Leader, Danielson, Zenzinger, Colker, Bridges, Marchman, Winter, Fields, Henriksen, Sullivan, Jaquez Lewis, Cutter, Priola, Buckner, Michelson Janae, Roberts, Finberg. Please add the president. With a vote of With a vote of 14 ayes, 21 noes, 0 absent, and 0 excused, S003 to Senate Bill 3 is lost. Would the clerk please read the title to S004 to Senate Bill 3?
S004, amend the Judiciary Committee
Senator Van
reported.
Winkle.
Thank you, Mr. President. I move S004.
To the amendment, Senator Van Winkle.
Thank you, Mr. President. This amendment, what it attempts to do is it takes the very generic term firearm crimes and puts a definition to it by pointing directly in Statute 18 to the 8 specific and yet still broad firearm crimes that are listed in Title 18 so that this task force may investigate those 8. I don't need to go through them all, but it's essentially the 8 that are listed there in Title 18. And then at the bottom, it has a catch-all and says any other criminal offense may be investigated with prior consent of local law enforcement. I ask for a yes vote.
Senator Sullivan.
Thank you, Mr. Chair. I ask for a no vote.
Mr. Minority Leader.
Thank you very much. I rise in support of this amendment. What I like most, I like the whole amendment. I mean, there are 3 pieces to it that are good, but the one I like most is once you establish this consent with local law enforcement, you've got the relationship in the proper order, gives you the ability to follow the leads, see where the investigation takes you. It gives you the authority to pursue any other criminal offense discovered during an investigation pursuant to the various sections of the bill.
Seeing no further discussion, the motion is the adoption of S004 to Senate Bill 3. Are there any no votes? Senators Exum, Mullica, Roberts, Hansen, Gonzalez, Colker, Rodriguez, Winter, Danielson, Janal, Finberg, Zenzinger, Bridges, Marchman, Fields, Henriksen, Sullivan, Jaquez Lewis, Cutter, Priola, Buckner, Michelson Janae. Please add the president. With a vote of 12 ayes, 23 noes, 0 absent, and 0 excused, S004 to Senate Bill 3 is lost. Would the clerk please read the title to S005 to Senate Bill 3?
S005,
Senator Van
amend the
Winkle.
appropriations.
Thank you, Mr. President. I move S005.
To the amendment, Senator Van Winkle.
Thank you, Mr. Chair, or Mr. President. And what this amendment does, members, is it would start this brand new office essentially with 5 FTEs instead of 10 and fully funds all the lab equipment and the other equipment that is in the bill, like such as office space. So I ask for a yes vote to start the office with 5 investigators instead of 10.
Senator Sullivan.
Thank you, Mr. President. I ask for a no vote.
Seeing no further discussion, the motion is the adoption of S005 to Senate Bill 3. Are there any no votes? Senators Exum, Mullica, Roberts, Hanson, Gonzalez, Colker, Rodriguez, Winter, Danielson, Janal, Zenzinger, Marchman, Fields, Hendrickson, Bridges, Sullivan, Jaquez Lewis, Priola, Cutter, Moccasin Janae, Buckner, Finberg. Please add the president. With a vote of 12 ayes, 23 noes, 0 absent, and 0 excused, S005 to Senate Bill 3 is lost. The question before the body is the adoption of the Committee of the Whole report. Are there any no votes? Senators, Mr. Minority Leader Kirkmeyer, Gardner, Rich, Pelton B, Baisley, Pelton R, Will, Van Winkle, Smallwood. With a vote of 25 ayes, 10 noes, 0 absent, and 0 excused, the Committee of the Whole report is adopted. Senate Bill 003 is amended. Senate Bill 150 is amended. 001 is amended. 14 is amended. 19 is amended. 20 is amended. And 65 is amended. Passed on second reading, ordered, engrossed, and placed on the calendar for third reading and final passage. Consideration of resolutions. Will the clerk please read the title of SJR 014?
SJR 14 by Senators Danielson and Simpson and Representatives McLaughlin and Catlin concerning a joint session of the Senate and House of Representatives for the purpose of hearing a message from the representatives of the Ute Mountain Ute Tribe Tribal Council and the Southern Ute Indian Tribe Tribal Council, and in connection therewith appointing a committee to escort the tribal representatives.
Senator Danielson.
Thank you, Mr. President. I move SJR 24-14.
Is there any discussion? Senator Danielson.
Thank you, Mr. President. Just briefly, we won't ask you to read it at length, but just to draw particular attention to Friday's activities, both of the chairmen of the Ute Nations, the Ute Mountain Ute and the Southern Ute Indian Tribe, will be addressing us, and it's only this, I think, the second time that this has ever happened. We're really proud of this. It's an opportunity for us to learn what's happening with these nations within our state's borders, and also the Ute people in Utah. And in the coming hours and days leading up to the address, and then after that on Friday, if you have a request for a meeting with any of the council members or the chairman themselves, please take them up on it and listen to what's happening in their communities and what we as the legislature need to do right by the tribal nations that we are so lucky to call our friends and neighbors. And I'm looking forward to Friday, and I want to thank my co-sponsor. Obviously, the Ute Nations are in his district, and he's very closely tied to the people that we care about and are talking about today. So I just wanted to thank you all for your attention on Friday and acknowledge it's a really special thing. We should have been doing this for generations, but hey, better late than never. Now that they're coming to visit with us, let's do what we can to uphold the values and do right by our friends and neighbors in the Ute Nations.
Senator Simpson.
Thank you, Mr. President. Thanks to my good colleague, the good senator from Wheat Ridge. And just a reminder, this is part of Ute Day at the Capitol. So this is the joint resolution that announces they're going to give that address to both bodies on Friday morning. So thank you very much.
Oh.
Senator Danielson.
Sorry, one more thing. Thank you to my colleague here. Great reminder. I'm sure you'll get another one tomorrow, but there are activities all day on Friday, in the morning and following the address. So please, as your schedule allows, we know that you have a lot of demands on those schedules. Take a moment and visit whichever piece of it you find convenient. You won't regret it. Thank you.
Seeing no further discussion, the motion is the adoption of SJR 14. Are there any no votes? With a vote of 35 ayes, 0 no, 0 absent, and 0 excused, SJR 14 is adopted. Co-sponsors, Senator Danielson.
Thank you, Mr. President. I would move that the day's roll call be added as co-sponsors without objection.
Seeing no objection, the current roll call will be added as co-sponsors.
Thank you. We'll see you on Friday. We'll see you tomorrow.
Consideration of memorials. Will the clerk please read the title of Senate Joint Memorial 002?
Senate Joint Memorial 2 by Senators Roberts and Simpson, Representatives McCluskey and McLaughlin, memorializing Congress to fully fund the authorized $35 million to the Water Infrastructure Improvements for the Nation Act, according to the recommendations of the Colorado River Drought Task Force.
Senator Roberts.
Thank you, Mr. President. I move for the passage of Senate Joint Memorial 2.
Is there any discussion? Senator Roberts.
Thank you, Mr. President. Colleagues, this is also a memorial that we'll be discussing as part of Tribal Nation Day over in the House. But this is a follow-through on the Colorado River Drought Task Force. As you all might remember, I believe that bill passed this body unanimously last year. It created the task force, but also the sub-task force of tribal matters to discuss water issues specifically related to tribal nations in Colorado. In this memorial, excuse me, which urges Congress to fully fund the Water Infrastructure Improvements for the Nation Act, was one of their recommendations. They actually asked for us to just send a letter to Congress, but I'm very happy that we've been able to move forward and formalize it as a joint memorial. By fully funding the Water Infrastructure Improvements for the Nation Act, specifically in Colorado, would allow more funding to go to the Pine River Indian Irrigation Project, which my colleague can speak more to, but it has significant aging infrastructure, the canals and the water infrastructure that serves southern Colorado and the tribal nations in that area could really use some increased federal funding to help improve water service to the tribal nations as well as the agriculture that is dependent on it. So this is a memorial to the U.S. Congress to fund that program and would be a great start to help our tribal nations with their water concerns, and would ask for an aye vote.
Senator Simpson.
Thank you, Mr. President. Thanks to my good co-prime, the good senator from Frisco. And again, recognizing there is an abundance of need where the federal government has not lived up to their commitment over the years to really assist in infrastructure improvements that are much needed, particularly in the Ute tribes in southern Colorado. So the memorial is well deserved and fully supported, and seek your support as well.
The motion is the adoption of Senate Joint Memorial 2. Sorry to scare you, Cindy. Are there any no votes? With a vote of 35 ayes, 0 no, 0 absent, 0 excused, Senate Joint Memorial 2 is passed. Co-sponsors. Senator Roberts.
Thank you, Mr. President. I'd ask that the current roll call be added as co-sponsors.
Seeing no objection, the current roll call will be added as co-sponsors to Senate Joint Memorial 2. Message from the governor.
Tuesday, March 12, 2024, honorable members of the Colorado Senate, pursuant to the authority vested in the office of the governor of the state of Colorado, I have the honor to inform you that I have approved and filed with the Secretary of State the following acts. Senate Bill 45, modifications to sterilization requirements for cats and dogs, approved on Tuesday, March 12, 2024 at 6:15 p.m. Senate Bill 31, local authority enforced violation of Noxious Weed Act, approved on Tuesday, March 12, 2024 at 6:15 p.m. Senate Bill 157, Colorado Open Meetings Law for the General Assembly, approved on Tuesday, March 12, 2024 at 6:15 p.m.
Committee reports.
March 11, 2024, Committee on Transportation and Energy, after consideration on the merits, the committee recommends the following. House Bill 1012 be amended as follows, and is so amended, be referred to the Committee of the Whole with favorable recommendation, and with the recommendation it be placed on the consent calendar.
Introduction of resolutions.
Senate Resolution 3 by Senator Zenzinger concerning the recognition of Single Parent Day.
Mr. Majority Leader.
Thank you, Mr. President. I move that SR 003 lay over until Thursday, March 21st, 2024.
The motion is to lay over Senate Resolution 3 to Thursday, March 21st. All those in favor say aye. Opposed, no. The ayes have it, and Senate Resolution 3 will lay over until Thursday, March 21st. Introduction of bills.
Senate Bill 181 by Senators Pierola and Hanson, Representatives Degree, Kennedy, and Amable, concerning the creation of the Colorado Alcohol Impact and Recovery Enterprise.
Finance. Senators Marchman and Roberts and Simpson are appointed to escort the tribal representatives to the joint session on Friday. Announcements. Senator Hanson.
Thank you very much, Mr. President. Members, considering there may be a snow day tomorrow, just maybe, don't know yet, anything could happen. But if that does occur, I thought I better let folks know that we will continue to meet with the Property Tax Commission on Friday. The remote option will be available. We'll be taking final votes on a number of recommendations. Everyone very welcome to join us and participate in that discussion, and we will have recommendations for the full General Assembly by the end of that meeting. Hope to see you on Friday.
Senator Bridges.
Thank you, Mr. President. Should the Senate be delayed on Friday, the Appropriations Committee will meet half an hour before the start of the delayed start of the Senate. If we meet on time at 9, then we will be meeting at 8:30 a.m. However, if for some reason the snow apocalypse is bad enough that they delay our start on Friday to say 10, for example, we would meet at 9:30. If they delayed us till 10:30, we would meet at 10, and so on. Do the math. Half an hour before the start of the Senate Appropriations Committee will meet on Friday. If the Senate does not meet on Friday, we will not meet.
Senator Fields.
Thank you, Mr. President. Members of the Senate Health and Human Services Committee, we will meet at 325 in SCR 357.
Senator Gonzalez.
Thank you, Mr. President. Upon adjournment of the Senate Education Committee, whenever that is, but hopefully briefly, I'm sorry, not HHS. Upon the adjournment of Health and Human Services Committee, whenever that may be, hopefully promptly, the Senate Judiciary Committee will meet at the old Supreme Court to hear House Bill 1079.
Senator Buckner.
Thank you, Mr. President. Senate Education Committee will meet after HHS in room 357. We have some appointments, and we also will be hearing Senate Bill 088, 1082, and 101.
Senator Priola.
Thank you, Mr. President. I don't know if there's an announcement or asking for a personal privilege, but hopefully I'll ask for a personal privilege just in case.
Granted, as long as you stay within the rules of what a personal privilege allows
Okay.
for.
Everybody, I know we're all getting ready for the snow apocalypse, and I hope it becomes as advertised because we need the moisture, but I just wanted to let the body note that the U.S. just had its hottest winter on record. The lower 48 states just experienced their warmest winter on record this year, with extreme temperatures departing from average observed across the northern tier of the country, according to NOAA. Why it matters. The lost winter of 23-24 will be known for its lack of cold, snow, and ice. Instead, it will be known as a wet winter across the East Coast, part of central states, especially Southern California. Driving the news, according to NOAA, some of the typical coldest states in the country saw record-setting warmth. North Dakota, Minnesota, Wisconsin, Iowa, Michigan, New York, Vermont, New Hampshire. For the country as a whole, the meteorological winter, December through February, had an average temperature that was 5.4 degrees Fahrenheit, not Celsius, 5.4 degrees Fahrenheit above for the season, beating the winter of 2015-2016 for the title. Part of the upper Midwest had temperatures analogous
that exceeded the 20th century average of 1901 to 2000 by more than 10 degrees Fahrenheit, which is an unusual large margin for a seasonal record. Consistently above temperatures across the Midwest and Great Lakes led to just 2.7% lake ice cover on February 11th, the lowest on record for that time of the year, NOAA found. So again, I hope we do have the advertised snow apocalypse because we need it, and sorry to rain on the oil and gas day at the Capitol, but that's the news.
Senator Pelton.
Thank you, Mr. President. And I thank the good senator for coming up here and talking to us about that from Henderson, because it also makes the growing season longer so we can feed more people. And the best part about it is that the Eastern Plains are creating all the kilowatt hours for the greenhouse gas roadmap that everybody likes so much, and the siting that the county is doing with the green energy. So if it wasn't for the Eastern Plains and all the wonderful green energy that we produce out there, it's a good thing. So thank you for the good senator from Henderson.
Senator Pelton, did you ask for a moment of personal privilege? Ah, interesting. Please remit $5 to the Senate Secretary. Senator Coleman.
Thank you very much, Mr. President. Request a moment of personal privilege.
Granted.
Thank you so much, Mr. President. You know, members, we do a lot of work down here, but we know we're all supported by amazing people in our lives that make this possible. And today, I want to recognize, in my personal opinion, the most amazing woman ever, my wife, Shayna. We're celebrating 14 years of marriage today. And I just want to give her a shout out. Thank you so much for loving me and allowing our family to do this work and putting up with me for 23 years since 8th grade. That's all. Thank you, Mr. President.
We don't know how she does it. Senator Pelton.
Thank you, Mr. President. I'm going to request a moment of personal privilege just to cover
Your
myself.
bases. Granted.
Thank you. Earlier this week, I came down and announced that Shinewell's boys were state champions in 1A. First time in 69 years. Lyman is the 2A champion, boys team, first time in 60 years. So just wanted to announce that. Thank you.
Senator Simpson.
I'm going to live on the edge and make an announcement that there are, there were 5-pound bags of potatoes in the back, both yellow gold potatoes and then russet potatoes. It looks like all the yellow potatoes are gone, but please help yourself, as those are compliments of the Colorado Potato Administrative Council in the San Luis Valley. These are all homegrown, grown from certified seed too, so enjoy.
Senator Michelson-Janae.
Since Senator Coleman, the senator from Denver, set the stage, happy anniversary to you, my beautiful husband, and I'm so grateful to you for the 13 years of our marriage.
Wait a minute.
Personal privilege, please.
The real question, wait, you guys are married? Senator Michelson-Janae, because you're new around here, you will only be fined $1. Senator Priola, I think you've extinguished all of your time.
Mr. President, I'd like to ask for a personal privilege again.
No.
No, come on.
Who's next?
Come on, granted.
I did not grant such privilege.
All right.
I dare you. Senator Priola.
Thank you, Mr. President. Well, just so I'm finally early for once, I will be celebrating my 28th anniversary in 10 days, so.
Senator Priola, I did call on you, but I did not grant you the personal privilege. So you will now be fined $1. Listen up, snowflakes. I think the majority leader is going to make an announcement about tomorrow.
Colleagues, weather permitting, there will be a joint session in the House chamber on Friday, March 15th, after we recess or adjourn to hear the State of the Tribes address. A seat will be provided next to your counterpart in the House. As many of you know, we've been watching the weather. The minute Pueblo school districts call a snow day, we will close tomorrow. I'm just kidding. We will have tomorrow off. Enjoy your day. Plan to be here Friday. We'll let you know if we're having a late start or anything else. On that, Mr. President, I move the Senate adjourn until 9 a.m. Thursday, March 14th, 2024.
Hold on. Thursday. Members.
Friday. Because I called a snow day.
Mr. Majority Leader.
I now move that the Senate adjourn until Friday, 9 a.m. Friday, the 15th, pending late notification.
Members, let it be known that if this ends up being a little drizzle, and we didn't need to have this snow day you've all been begging for all day, we reserve the right to come in on Saturday to make up the work. The motion before the body is to adjourn until Friday, March 15th at 9 a.m. All those in favor say aye. Aye. Opposed, no? The ayes have it. The Senate will adjourn until Friday, 9 a.m., March 15th.
Aye.